Bertsch from Texas Grandparents Raising Grandchildren. I want to welcome all of you to our first Ask a Lawyer seminar. I want to introduce Renee Trevino from Texas Real, who is going to be doing the part of the presentation and the introductions of the webinars. So thank you so much.
Thank you, Mercedes. So first of all, we want to acknowledge the organizations who are essential in having this training today. And so I'm going to allow Hillary Showers from SALSA to introduce herself.
Hi everyone, I'm Hillary Showers. I'm San Antonio Legal Services Association's Family Law Fellow, and San Antonio Legal Services Association also is a nonprofit organization that mobilizes volunteers providing legal services to transform the lives of San Antonio and surrounding areas, indigent, vulnerable, and at-risk populations.
Greg?
Thanks so much, Renee and Mercedes, for convening us. My name is Greg Zlotnick. I direct the pro bono programs at St. Mary's University's School of Law at the Center for Legal and Social Justice. Some of you all attending today may be familiar with the work of our clinical programs. Of course, as teaching programs, we can only take so many cases in through our clinics, which is why through the pro bono programs, we are so excited to be able to partner with Texas Rio Grande Legal Aid, with SALSA, and with other legal services providers across the San Antonio area and the state to be able to connect our students with the great work of those organizations and to provide greater assistance to our community.
Thank you, Greg. And I'm Renee Trevino. I am an attorney with Texas Rio Grande Legal Aid. Texas Rio Grande Legal Aid, or TRLA as we call it, is a private nonprofit law firm. We provide free legal representation to low-income individuals. Our service area covers 68 counties, all of South and West Texas pretty much. One of the things that we wanted to make sure everybody knew, and we'll be reminding you of as we go, there is going to be question and answers. There is a button on your screen that allows for question and answers. Different panelists are handling questions differently. For Carol Bertsch, who's going to be our first speaker, she's saying that she's open to questions during the presentation. So if you put questions into the question and answer button, I will ask the questions for Carol. One of the other things that we want to do as TRLA is just let people know that we are not going to answer, or none of our panelists rather, will be answering specific questions to a specific case. We don't want to do that because we don't want to breach attorney-client privilege, for one thing, and just basic confidentiality. So on your questions, please make them general. This is meant as legal information and education. And as you know, Mercedes with Texas Grandparents Raising Grandchildren will have a list of people who do want specific legal questions answered. And we're going to have a mechanism to contact the people who may have those requests. So with no further ado, I'd like to introduce Carol Bertsch. Carol Bertsch is an attorney here in San Antonio who specializes in estate planning. So, Carol.
Okay, thank you, Renee. I'm going to share my screen. We make sure that everyone can see that. We're going to talk about estate planning. And you may be thinking to yourself, why in the world do I have to do estate planning? I've already got plenty on my plate. And here this Carol Bertsch is asking me to do one more thing. Well, I'm going to let you in on a secret. It is highly confidential information, so listen closely. Every one of us is going to die. Maybe not today, maybe not tomorrow, but in the future. And that's why we have to plan, because we know it's coming and we have to plan for it. So when we're planning, we have to remember, or when we're thinking about planning, we have to remember that we have some grandchildren who have means-tested public benefits. I don't want to get too basic for y'all, but I want to make sure that we're all on the same page. Means-tested means that you can't have too much money. So if you have a grandchild who's getting SSI, for example. That's means tested. That means that the grandchild can't inherit from you and still keep their benefits. Now, that's in comparison to SSDI. So maybe if you're raising a grandchild or you have a grandchild whose parent died, they're getting SSDI. That's not means tested. So they can inherit from you and not get kicked off of their benefits. Medicaid is means tested. Your grandchild with Medicaid is going to get kicked off of their benefits if we don't plan ahead for the time when you die. Versus Medicare, if you have a grandchild getting Medicare, that is not means tested. But I just wanted to go over those basics with you to make sure that you understand that if you die and your grandchildren inherit from you, it could have disastrous consequences for their means-tested public benefits. So we have some planning options. One of them is do nothing. And that one is not what I recommend, but you certainly could. And if you have a grandchild who is going to inherit from you because your child has died and the grandchild is next in line, then doing nothing is going back to what I was saying before, could be disastrous for their means-tested public benefits. Another way of planning is to use a will. A will is a document that lets you say who gets your stuff at your death. Most everybody's heard of a will, and you may think, oh, you know, that's way too complicated. I don't want to do a will. And I don't blame you. It is complicated, but it's an option that we want to try if we're thinking about protecting our grandchildren. We don't want them to inherit outright if they are minors or if they are persons with a disability. And if they're a person with a disability, instead of just doing a plain will, we want to do a will with a special needs trust. That's another option for planning. A will with a special needs trust is just a will that has a special kind of trust in it that allows a person who's getting means-tested public benefits to still qualify for those benefits. So you do a will and it has this special trust in it. And then your grandchild who's getting SSI doesn't get kicked off of their benefits. Now you may be thinking, Carol, look, all I've got is a house. I don't need to do a will. Then what we might do is a ladybird deed or a transfer on death deed. And we're going to talk about those too. Okay. So I see I got ahead of myself. If we do nothing and your grandchild inherits, are they going to get kicked off of their means-tested public benefits? If you just have the house and you do nothing, are they going to be able to keep up the house when they inherit it? So are they going to be able to have the funds to pay for repairs? If they're just getting SSI, how are they going to pay for their utilities? How are they going to pay for maintenance? If you decide, I'm not going to do anything, I'm going to let my grandchild inherit my house, it could be that they're not going to be able to take care of that house and they're going to have to sell it. If they sell it, the proceeds from that sale are going to kick them off of their means-tested public benefits. So again, we have the problem with doing nothing, which is that it can possibly kick our grandchildren with disabilities off of their means-tested public benefits. So let's say we do a will, and we do a will with a special needs trust so that the grandchild can keep their means-tested public benefits. But is that too much? is that more legal help than you need because it's overcomplicated and it's expensive? That's possible, but the biggest disadvantage, if we just do a will, is that we are possibly exposing your house to the MERP program. MERP is the Medicaid Estate Recovery Program. And what it says is, if you need Medicaid or you have Medicaid and you're over 55 and you get long-term care Medicaid, like with a nursing home, then after your death, the state wants your beneficiaries to sell your house and pay them back, pay the state back for what it spent on your care. Now, there are exceptions to the Medicaid Estate Recovery Program, but those exceptions in general are not going to apply if you've got, well, some exceptions apply, but let's say you don't have an exception because we've got grandchildren with a disability, not a child with a disability. So we want to protect that house, your house, from MERP. We don't want to lose it if you need Medicaid in the future. So what are we going to do? Again, we can do a will, but we have MERP to worry about. So what's our option? Another option is to use something called a ladybird deed. Now, what a ladybird deed does is say, I keep my house for as long as I live, and I get to change my mind about who gets it at my death. So if I decide that one of my grandchildren is getting a little too sassy with me, I can change my mind and say, okay, grandchild, you don't get my house at my death. But the good thing about the ladybird deed is it avoids Medicaid estate recovery. That's because the ladybird deed passes the title to the house automatically upon your death. And so the Medicaid estate recovery program doesn't apply. The good thing about a ladybird deed is the grantee, that's the person who gets the trust, the house upon your death, can be a trust, including a special needs trust. Now, remember, I said a special needs trust is a special kind of trust that allows your grandchild with a disability to get the benefit of the house without getting kicked off of their means-tested public benefits. Okay, so a ladybird deed is useful in making sure that your grandchild with a disability gets the benefit of the house and still keeps their SSI and their Medicaid. Now, there's another kind of deed called the transfer on death deed, or TODD, or TOD. And that is something you may have heard of. It's like a ladybird deed. It says, I keep my house as long as I live, but upon my death, it passes to whoever I want it to go to. And a transfer on death deed can be very useful. Here's my concern. If the house needs to be sold within 2 years after your death, sometimes we have difficulty getting that sale accomplished when we've got a transfer on death deed. That's because the law that establishes the TOD, the transfer on death deed, allows creditors, those people who you owe money to come back against the house for 2 years after death. Now, it doesn't allow MERP to come against the house, but it allows other creditors like credit card companies to come back against the house for 2 years. And the concern is when you sell that house and you have to get title insurance, or your buyer has to get title insurance to buy the house, the title company doesn't want to insure title until the 2 years have passed. Now, if your beneficiary is going to live in the house and not going to sell it, that's great. We don't have to worry about that 2-year problem period. But if your beneficiary can't hold on to the house, for example, they don't have the money to pay for upkeep or repairs or utilities, or they can't live alone in the house, then we've got a problem, because we've got a house we can't sell, and we've got a beneficiary who we don't want to get proceeds unless it's in a special needs trust. So that's why and let me go back, I should have said, the transfer on death deed can also pass to a special needs trust, but the 2-year period where we can't get title insurance, that's the main concern I have about the transfer on death deed. So again, the transfer on death deed and the ladybird deed do very much of the same thing. But the ladybird deed, if the house has to sell within 2 years, the ladybird deed is the way that we want to go rather than the transfer on death deed. Okay, so let's go back over that for a minute. If you owe money on your house, if your house is not paid for, in general, we don't want to use the ladybird deed. We want to use the transfer on death deed, because the law says that we can use a transfer on death deed even if we owe money on us. If we use the ladybird deed, we've got to get the lender's permission before we do the transfer, before we say, I'm giving my house to grandchild X at my death. So there's drawbacks to the ladybird deed, and there's drawbacks to the transfer on death deed. And we need to know specifically what we're dealing with to know which deed is the best choice for us. When we want to do planning, it's very important that we utilize a lawyer who's experienced with means-tested public benefits. Now, that could be a lawyer at Texas Rio Grande Legal Aid. It could be a lawyer who's an elder law attorney out in the community. It could be a lawyer from SALSA. But we've got to make sure when we bring this to the lawyer that the lawyer knows if we're dealing with a person with a disability, because dealing with a person with a disability changes our options. We want to make sure that we protect those means-tested public benefits that the person with the disability has. And that is why we've got to, when we're talking to the lawyer, we've got to be sure that we bring that up. Now, I know you're thinking, why do I have to see a lawyer? Lawyers are expensive, and I don't really like lawyers anyway. And I don't blame you. Lawyers are very problematic. They make things more complicated. But we have a complex situation here. We have a situation where we've got someone with a disability, and that makes things more complicated. Or we've got a situation where we've got a grandparent and a grandchild, and we don't have a parent in between, and that can make things more complicated. So it really does benefit everyone if you talk to a lawyer And I know this sounds self-serving because I am a lawyer, but I really don't want you to get your legal information off the internet, okay? Because the damage, if you go to the internet and you utilize that information, the damage that can be done is that it can kick your grandchild off of their means-tested public benefits for a year or 3 years. And you don't want to do that. And if you kick them off Medicaid, then they don't have their health care. And if you've got someone with a disability who needs that health care, you've really kind of messed things up. So if you can overcome your objections to utilizing a lawyer, I strongly, strongly recommend that you go that route instead of going along with the internet, okay? And instead of going along with what your friends might be telling you worked for them, because remember that every situation is different and you don't know what was going on in their financial situation. Maybe they have a house with a loan on it, so they needed a transfer on death deed. And they tell you, oh, you've got to use a transfer on death deed. You need that, not a ladybird deed. But if your house is paid for, a ladybird deed is a better choice for you. So you don't always know what's going on in their situation. So you can't judge your situation by what your friends are telling you. Now, I don't see if we have any questions. Let me just see.
At this point in time, we don't have any questions from the public.
Okay, wow. Well, I've been very clear. I've been too clear. Let me go back and make it confusing for you so you have to ask questions. Another thing that you really want to have when you are taking care of your grandchildren is someone as a backup to manage your finances for you and your health care for you as you're taking care of them, and someone who can be backup for you to take care of them. For example, you want to have a financial power of attorney that says that someone can make financial decisions and help handle your finances for you, as well as someone who can make medical decisions for you if you become incapacitated. And those are called powers of attorney. If you are helping a grandchild who is an adult with a disability, you may want to get powers of attorney from that grandchild rather than going the guardianship route, because guardianship can be extremely expensive and very burdensome. So if you are able to, if your grandchild with a disability has enough capacity to give power of attorney, that is an important document that you need to get from them. Another way to help your grandchild with a disability make decisions is to be a supported decision maker. So that is someone who the grandchild says, this is a person who makes decisions, helps me with my decision making. She doesn't make decisions for me, but helps me make decisions. The supportive decision-making statute is a really big help when you've got someone with a disability, with a mental disability, who maybe needs a little assistance making decisions. So you want to make sure that you're covered in having someone to make decisions for you if you become incapacitated, as well as being able to handle making decisions for your adult grandchildren with the powers of attorney. So you've got a power of attorney for yourself, and your grandchild has given you power of attorney to act for them. Or instead of utilizing the power of attorney, you're the supported decision maker for your grandchild. So I was hoping that we would get more questions, so I didn't prepare a lot more for us to talk about.
Just for clarity, in order to ask a question, go to the button that should be at the bottom or the side of your screen where it says Q&A and type in your question, and then we'll ask Carol your question. In the meantime, I do have a question for you, Carol.
Yes.
One of the things you talked about are the dangers of not having a will or estate planning upon your death. And so I was wondering if you could spend this time that we have to talk a little bit about in Texas, what happens to a person's estate or all their belongings if they die without a will? How is it distributed?
That's a great question. So when you die without a will, the law sets out who gets what you have. If you have a spouse and all of your children are your spouse's children, then your spouse is going to inherit your share of the community property. So let's say you've got a spouse and y'all have a house that you bought together, and all of your children are their children. That means that they don't have a child from another relationship and you don't have a child from another relationship. So everybody's got the same children. When you die, the house, your share of the house, passes to your spouse. However, let's say that you're married to someone who had a child from another relationship, and at your death or at their death, instead of their share of the house passing to you, it passes to their children. And if their children are deceased, it passes to the grandchildren. Now, this can be a big problem because then you end up owning your share of the house along with their share of the house goes to their children. And you have a surviving spouse homestead interest in the house. That means that you can stay in the house until your death, but you don't have the ownership of the house in full. You just own your half. Now, let's say you're single and you're raising your grandchildren because your child has died. At your death, your house is going to pass to those grandchildren. Or let's say you have 3 kids and
All right, we have a momentary glitch. Let's wait for Carol to come back online. Carol, if you can hear me right now.
Okay.
Carol, you were interrupted. So you're talking, you probably were interrupted about 30 minutes or 30 seconds ago. So if you
I'm so sorry. I'm so sorry I froze. Let me see if I can't figure out how to get that stopped.
Well, that was the first time you froze, so.
Okay, good, thank you. So I was saying that if you have a house and it passes to your children, so you're single and you die and your house passes to your children, then you've got kids who say, oh, I want to stay in the house and keep it. And you've got kids who say, oh no, we need to sell that house. I want my share. And then it gets sold. And the part that goes to your grandchildren, if they're minors, then somebody has to become their guardian in order to receive that money. And that costs money. So that reduces the amount that they're receiving. And even worse, if they're on SSI, it's going to kick them off SSI because they've got too much money. Because for SSI, you can have no more than $2,000 in countable resources, and cash is a countable resource. So instead of your home passing in a protected way, it's going to pass in a way that kicks off your children, your grandchildren, or your children who are disabled, and it's going to make a mess. So much better to have a will that says who controls, or to have a ladybird deed to a trust that says who controls the house at your death. It's very, it just is creating an opportunity for lawyers to make some money if you choose to die without a will or without any planning ahead. And I know that you want me to make money. I know you want to pay a lawyer. So go ahead, die without a will and make me some money. That's a joke.
Okay. Carol, we do have a question from the public, but I wanted to plug in right now though. I added into the chat a link for the Texas Kin Care Primer. It is online at texaslawhelp.org. And it is a fabulous resource for non-parental caregivers, people who are rearing other people's children, whether it be grandparents or aunts or uncles, whoever it might be. So I just wanted to plug that really quick, let people know that exists. It's a free resource. And as opposed to other sites on the internet, is based in Texas law, number one, which is very, very important. And number two, it's been put together by nonprofit attorneys and attorneys who are in the private bar, but it's put together, it's good law, they're good materials, so please use that resource. Now, the question we have, Carol, in general, if all of your paperwork is completed, proper designations are made based on your wishes, how long can it take to probate a will where everything is completely free and clear and the process is completed?
That is a great question. And you're not going to like the answer because it depends. And that's a lawyer answer for, I'm not sure. No, it does depend. If everything is in order and we don't have any creditors, we should be able to complete the probate process in about 4 months. The reason I say that it takes that long is we have to give some time just in case there are creditors out there. If we have to give them notice, we have to give them a chance to make a claim against the estate. Now, let's say there are no creditors. You don't have any credit card debt. You don't owe anything on the house. You don't owe anything on the car. Then really, now we do have to file the final tax return, income tax return the next year, but everything else can be completed in about 4 months. Now, if you have a situation where you've got people who are fighting, or you have beneficiaries who are saying, oh, I want mom's china, or no, I want the watch that dad got from his grandfather, or I want this, or I want that on the personal property, then it can take longer because we need an executor to make decisions and clarify things and have people's gifts, personal property distributed as per their wishes. But, and if we have creditors, it does take longer because we've got to give them time to make their claims, and hopefully they don't make their claims and then it's barred after a certain length of time. Because if you give notice to a credit card company and they don't make a claim within 4 months, then their claim is barred. But if they do make their claim, then we have to decide whether we allow it or not and whether we pay it or not.
All right, we have 2 more questions. So the first question is, what exactly is probate?
Okay, probate is just an orderly process for making sure that the deceased person's property goes to the people it's supposed to go to. So let's say we have a house and you have a will. We want to make sure that that will is valid, that nobody forged it and nobody unduly influenced you or threatened you or coerced you to say, give your house to me. So we file the will with the court. The judge reviews the will and the paperwork to say, yes, this is a valid will, and you should be appointed, you being the person who brings the will, should be appointed executor. And then the executor makes sure that there's an orderly transition of the property to whoever you gave it to in your will. So if we have, and again, I keep bringing up creditors, we also want to make sure your bills are paid before your estate gets distributed, your property, your house gets distributed to your beneficiaries. And probate is that process. It can be difficult if you don't have a will, because then we have to do an heirship determination. We don't always have to, but sometimes we have to do a determination to figure out who are the right people to inherit from you. So the law says who is the right people, but we've got to establish, do those people exist? So do you have a spouse? Did you have children? If you didn't have children, or your children are deceased, who does inherit? Who are your grandchildren? So an heirship determination is much more expensive and time consuming. And we want to avoid having to spend that much money by doing a will.
So just in short, is when you take the will to court to probate it, is that the same as filing a lawsuit?
Well, that's a good question. I don't consider it the same as filing a lawsuit, because usually when you file a lawsuit, you've got an opposing party, like you're suing somebody. But I guess from a legal procedure standpoint, it's similar to filing a lawsuit. You file it with the court and you go in front of a judge, but there's nobody, unless it's contested, unless somebody says, oh no, that's not a valid will, or that's not her last will, she left another will that wrote in that left everything to me, then it's definitely a lawsuit.
Okay, next question. What if you adopted your grandchildren and did not have time to add them on your will? Will they have the same rights on your property as your biological children?
Another it depends question. It depends on what you say in your will. So if your original will, before you adopted your grandchildren, if it said something like, I leave everything to my descendants, and descendants includes my children that I have, as well as the children that I might have in the future, then you're home free. If it doesn't say that, there is something called the pretermitted child, that if a child is born or adopted to you after the will, they get the same share as the children who are already in the will. So if you did, my best advice is to go ahead and do a new will that includes the adopted child. But if you did adopt the child and you didn't change your will, unless your will says something like, my children are this, this, and this, and these are the only people who I include as my child, then you should be okay.
All right, next question. What happens if you get a ladybird deed and add more than one person on there, like the child and the grandchild? And what if the grandchild has Medicaid?
Okay, what I would recommend, and I know this makes it more complicated, but you want to do a ladybird deed where the grantee is a trust. What that means is you say, I leave my property in, or I grant my property to and you can name the child as trustee, the trustee of the family trust, and the trust has special needs provisions for the grandchild who's on Medicaid. Okay, so it makes it more complicated, and it does make it a little more expensive, but it protects the grandchild's Medicaid. Now, if you just have two children and you want to say, I leave it to, I grant the grantees of the Lady Bird deed are the 2 children, that's no problem. But if we've got someone on Medicaid, we don't want them to inherit it outright.
All right. Next. Let's see. All right. Here's another question. So the question is, are you saying you either pay an attorney now or your heirs will pay for an attorney later?
Oh man, I could have planted that question. That is great. It is true that somewhere down the line, lawyers write the laws, and so lawyers make sure that lawyers get paid, I guess. But it is true that if you don't take care of it now, then somebody is going to have to take care of it down the road. And there's probably going to be a lawyer involved.
And it'll probably be a little bit more complicated down the road. Is that
It
also what
will
you're
be.
saying?
Yes, that's a great point. It will be more complicated. It's easier to plan it and take care of it ahead of time than it is to try to mop up the problems after the fact.
All right. And I do want to just make a comment. One of the questions that was asked, I asked it in an abbreviated way, because once again, we do not want to talk about a specific case or a specific situation, because this is an opportunity to ask questions and be educated. This is not the time that's appropriate to talk about specific cases, because we have confidentiality issues between an attorney and client and attorney-client privilege. So forgive me that I did not ask your full question, but we're not going to answer any case-specific questions. Next question. How much does it cost to do a will?
Okay, that's a great question. There are a number of low-cost options for wills. And so and I think I'm going to probably miss some of the options. SALSA, the San Antonio Legal Services Association, offers legal services by volunteer attorneys. The Alamo Area Council of Governments Area Agency on Aging offers legal services and low-cost legal services and can do documents for you. The Catholic Charities offers legal documents. I think there's a long waiting list for them, but that's some place to start. Of course, Texas Rio Grande Legal Aid, correct me if I'm wrong, Renee, do they provide provide wills?
Who's that? TRLA? Yes.
TRLA, yes, okay. So there are lots of options. If you are getting a private attorney, I'm trying to think about what other options you have. It can vary if you're going out into the community, but don't go out and pay a lawyer if you can qualify for some of the lower cost options. And for example, with the Area Agency on Aging, all you have to be is over 60 to qualify for their services. So
All right.
I didn't name a specific number because I think there's lots of options to get it at a low cost.
All right, I'm going to ask this question first because I think it's very relevant to what you're speaking about. And then we have another question on another issue. What about online services? Would you recommend somebody using online services for will and estate planning?
Okay, that's a great question. Here's the deal. If you have a typical run-of-the-mill situation where you're a mom and a dad and you have a kid and the kid is over 18, I think an online service like, well, I won't mention them, but an online service would be fine. But if you're not a run-of-the-mill situation, for example, you're raising grandkids or you have a child with a grandchild with a disability, I think it's not as helpful, okay? Because their services are written to go with your more typical situation, and they don't have the tailoring that an unusual situation needs, especially for a child with a disability. So I would recommend against the online services unless you are in a real typical situation.
And just one little addition, and correct me if I'm wrong, Carol, but also you have to think about probate law, which is the law surrounding wills and estates, is state specific.
Absolutely.
How does that impact it?
Absolutely. So my understanding is that these online services take into account your locale, but I do not know for sure. Now, I have seen people who've used the online services and brought me that will, and there were things that we could have done differently. For example, here in Texas, it's very easy to probate if you have what's called a self-proved affidavit, or a self-proved will, a self-proving affidavit, which just means that the witnesses signed and the testator, the person doing the will, signed in the presence of a notary. And I have had online service wills that did not have the self-proving affidavit, so we had to get the witness to come to court for the probate. And I think that was because they were not Texas-specific wills. Even though the online service may have advertised that they were state specific, in that case it wasn't. So just keep in mind that laws vary state to state, and you've got to have something Texas specific, or it's easier and better to have something Texas specific. We can always fix the problem down the road, but it's not necessarily as easy or as inexpensive.
All right. Once again, we have another question from somebody who's adopted their grandchildren and they have adult biological children. What happens if they die without a will?
Well, hang on just a sec. I apologize for not turning my phone off. That was a good speaker habit. Turn your phone off before you start speaking. Okay, so the question is, we have children who are adopted and children who are biological, and we died without a will.
Yes.
All the children are going, so when you have an adopted child, that child is treated just as if that were a biological child. So all the children are going to inherit equal shares of the estate, and they're all going to be equal.
All right.
Does that answer the question?
I believe it does.
Okay.
So are you saying that when a child is adopted, they become your legal child and have the same rights as your other biological children?
Yes, exactly. Exactly.
Do we have any other questions? We've answered all the questions that have come so far. Okay,
Well, I appreciate y'all asking questions, because it's easier for me to make sure that I'm speaking about things that are interesting to you if you're asking those questions. So thank you for the questions.
All right. I'm going to wait just a minute longer, make sure we don't have any more questions.
Okay.
All right. Well, Carol, we do not have any more questions. So I want to thank you very much, Carol Bertsch, for your presentation and for all the information you have shared today. And just as a housekeeping matter, what we will do now is take a little break, and we'll resume again right at 11 o'clock. And our next session is with Julia Longoria from Texas Rio Grande Legal Aid, who will be talking about rights of children in education. and how grandparents can help enforce those rights. So thank you again, Carol. We still have no oh, hold it. We do have new questions. Just a moment.
Okay.
Just a second. Is there an age that is too young to get a will?
Anybody under 18 is too young unless they're emancipated, meaning that they've been made into an adult. They've had the restrictions of under 18 removed. But when you're 18, you need a will because you may have a car, and there may be ways that we can manage your estate even if you don't have a will, if you're that young, because you usually don't have that much property. But really, once you're 18, that's when it starts.
Okay, then that is the last question for this session. Once again, we will resume at 11 o'clock, and the next session will be on education. Thank you, Carol.
Thank you.
Hello, everybody. This is Renee Trevino from Texas Rio Grande Legal Aid. We will be starting our next session at 11 a.m. The topic will be on educational rights for children. So please stand by for just a couple more minutes. Good morning, everybody. This is Renee Trevino. I'm an attorney with Texas Rio Grande Legal Aid, and we welcome you to our presentation today for grandparents. A special shout out to Mercedes Bristol, who invited other organizations to join Texas Grandparents Rearing Grandchildren to do these presentations. Also involved today is St. Mary's School of Law and SALSA, the San Antonio, oh dear,
Legal
Legal
Services.
assistance. Thank you. I'm so sorry about that. So thank you for coming today. Also, the law office of Dominic Negrón was essential in pulling this presentation together. Our next presentation is by two of our Texas Rio Grande Legal Aid attorneys, Julia Longoria and Cesanu Wolderan. Forgive me if I mispronounce your name. I'll let you introduce yourself, Cesanu. And it is going to be on educational rights. A couple of housekeeping things first. Number one, we want to make sure everybody understands that today's sessions are educational to give you information, and we are not going to be discussing any case-specific issues. So in your questions, and please do ask questions through the question and answer chat. There's a button at the bottom or at the side of your screen that says Q&A. Please submit your questions there. Julia and Cesanu said that they are willing to take questions during the presentation. So if you have questions, ask them and they will be answered. So thank you for participating, Julia and Cesanu.
Good morning.
Thank you, Renee.
My name is Sinu Waldemariam, and I'm a staff attorney at Texas Rio Grande Legal Aid on our education team.
I'm Julia Longoria. I am the education team manager at Texas Rio Grande Legal Aid. We are happy to answer any questions as we go along. Like Beth, we really want to make sure that the areas of interest to you all are the areas that we answer. So with that being said, I'm going to share the screen and let Cesanu take.
Great, thank you, Julia. As Julia pulls up the slides that we'll be using to frame today's presentation, I do just want to reemphasize that we're happy to field questions using the question and answer function throughout today's presentation, as we want to make sure that the information we're providing is as closely tailored as possible to your specific questions, interests, and concerns. The general purpose of today's presentation will be ensuring that you have the tools necessary to advocate on behalf of your grandchildren in the school setting. And so we want to make sure that that information speaks to your needs. Great. As I previously said, the purpose of today's session is to focus on special education rights and how grandparents can help advocate on behalf of their grandchildren who may have special needs. We're going to be focusing on a couple of key points of law and trying to make them as clear, comprehensible, and practical as possible. All children have the legal right to an education, but that right is not one size fits all. Children with disabilities have the right to the supports and the services that they need to obtain a free and appropriate public education. Supports and services that may be academic, behavioral, social, or otherwise in nature. Unfortunately, while children with disabilities do have these rights, their needs are often treated as less important than those of other children. Often, they're allowed to fall through the cracks when they should be given just as much priority as children who do not have those special, particularized needs. Oftentimes, grandparents can have an especially difficult time advocating for the rights of the children that they're raising. Special education law can be complicated enough in its own right, and figuring out exactly what levers you can pull in order to get your grandchild extra help can be quite a daunting task, one that we're glad to be able to help you out with today. To that end, we're going to be talking with you all today about two particular laws that you can leverage in order to help ensure that your grandchild has the supports and services that they need in order to succeed in school. These two laws are called Section 504 of the Rehabilitation Act of 1973, or more simply, Section 504, and the Individuals with Disabilities Education Act, or more simply, IDEA. Before diving into the particulars of how these two laws work and how you can use them in order to advocate for your grandchildren, we do just want to note by way of preface that, as has been previously stated, this is not legal advice, and that, however, if you do require legal assistance, you may feel free to contact Texas Rio Grande Legal Aid using the information provided at the end of this presentation. We're first going to focus in on Section 504 of the Rehabilitation Act of 1973, or again, more simply, Section 504. And again, as we go through this material, please do feel free to jump in with questions so that we can help make sure we're speaking to your concerns. The purpose of Section 504 is to ensure that all children, regardless of disability, are given the accommodations that they need in order to obtain a free and appropriate public education. Section 504 applies to every single child attending a public school who has a qualifying disability. A qualifying disability is one which substantially limits one or more major life activities like reading, concentrating, or communicating. And we want to emphasize that the types of disabilities that can qualify for extra support under Section 504 are not necessarily strictly those that one might consider academic in nature. Section 504 applies regardless of whether the child's disability is cognitive, emotional, behavioral, or otherwise. Section 504 is a law that can be leveraged by grandparents who are raising their grandchildren. They may, depending on their circumstances, and rather they can, depending on their circumstances, have the same power as the grandchild's biological parents would to advocate for that child's special education rights. This power can come from any one of three different sources. The first is managing conservatorship. If you've been granted the status of managing conservator over your grandchild, then you have the right. Then you can use that to have the right to make education decisions on behalf of your child, especially special education related decisions on behalf of your grandchild. Another means by which you may obtain that power is a document called a power of attorney, which I believe was touched on previously and will, I'm sure, be discussed in greater detail later today. Power of attorney can come in various different forms, but the general idea is that it's a document that confers certain legal rights upon you. If your grandchild is under 18, Their parent may sign a power of attorney, giving you the right to make decisions about what is best for your grandchild. If your grandchild is over 18, they themselves may sign an educational power of attorney, a more limited document that only applies to school-related matters but confers similar authority. The third means by which a grandparent can have this power is through the federal special education law, which does define a parent as an individual acting in the place of or as a biological or adoptive parent, including a grandparent, step-parent, or other relative with whom the child lives, or an individual who is legally responsible for the child's welfare. This is all to say, in sum, that a grandparent can, depending on their circumstances, have the same right to make educational decisions, participate in educational decision-making, and to advocate on behalf of their grandchild's education and specifically special education rights as a child's biological parents would have. The first part of the process by which a child can obtain extra accommodations under Section 504 is identification. That is the identification of the child as one who is in need of and is eligible for extra supports. And again, please feel free to jump in with questions whenever you feel the need. The identification of a child who may have a qualifying disability under Section 504 is the responsibility of that child's school district. This responsibility is called Child Find. Every year, school districts have the responsibility to try and identify kids within their service area who may have qualifying disabilities. If a district knows, or if they even have reason to know, that a particular child may have a qualifying disability, they must refer that child for further evaluation. You do not have to approach your grandchild's school in order to request evaluation under Section 504. It is their affirmative responsibility, if they have reason to think that the child has special needs, to evaluate that child to determine what those needs might be and what kinds of accommodations and supports would be appropriate. If you believe your grandchild has needs that the school has not identified, a good first step is to send the school administration a written request to have your grandchild evaluated. We generally always counsel parents to try and keep written records of communications with the school and school district. Create a paper trail as early and often as possible, not just of your communications and requests for evaluation, but also of any observations that you might make or any observations that the school has communicated to you that could potentially be signs of your grandchild having unmet needs, such as, for instance, frequently recurring behaviors or academic struggles that the child manifests. These can all be used to help get your child more support. If your child's school district does not grant a request for evaluation, there are various tools that you can use to try and resolve the situation. You can file an administrative complaint with the Texas Education Agency, or TEA. You can request that the TEA provide mediation. You can request a sort of pseudo court process called a due process hearing, or you can file a federal complaint with the Department of Education's Office of Civil Rights. These are all tools that can be used in order to help ensure that your child gets the support that they need when negotiation with the district proves unsuccessful. You may wish to speak with an attorney before using them, as these processes can be difficult and daunting to navigate. If a child has been identified as one who may have a qualifying disability under Section 504, their district must act within a reasonable amount of time to get your consent to begin evaluating your child's needs. Section 504 evaluations need to meet certain basic standards. First, they need to be administered by trained and qualified personnel using validated and specific tests. Just having the vice principal that happens to be on hand eyeball what your grandchild needs doesn't cut it. Second, these evaluations need to be tailored to specific areas of need. If your grandchild has been identified as struggling in reading, for example, simply evaluating their writing and their oral communication skills are not enough. Third, Section 504 evaluations do need to account for your child's specific sensory and other needs. A child who has a visual impairment, for example, and prefers to use Braille that is something that needs to be taken into account when evaluating that child's capacities. Again, if you have reason to believe that these criteria are not being met and your district does not respond to requests, again, we advise that they be written requests, that they remedy the situation, then the same administrative remedies are available here. A complaint, mediation, a due process hearing, or a federal complaint to the Department of Education. If your child's district determines that the child has a qualifying disability, it must then gather what's called a 504 committee within a reasonable amount of time in order to draft a cohesive 504 plan. A 504 plan is a system of support for your child. The 504 committee must include persons knowledgeable about the child's needs, including the meaning of the evaluation data and the various placement options that are available to that child. This generally means teachers, administrators, special education specialists, and perhaps most importantly, the child's family, including grandparents if they are ones raising the child. We also, as a general matter, try to encourage having the child participate to the greatest extent possible in order to ensure that they're able to voice their perspective as to what works and does not work for them, and also to ensure that the child believes in and feels comfortable with the plan, in addition to knowing what's in it, so that they can help themselves by advocating that it be effectively implemented, asking for their accommodations when necessary. As the 504 plan is being developed, it's important to bear in mind that it covers these three themes. First, that it meets your child's right to accommodations that address their intellectual and social-emotional needs. Again, we really do want to emphasize that 504 plans aren't just about making sure that your grandchild can complete their academic work, but also making sure that the school environment is one where they can feel safe and comfortable. Second, it's important to ensure that the 504 plan gets your grandchild those accommodations in the least restrictive environment possible. They have the right to be, to the greatest extent possible, integrated into the general education setting, rather than segregated.
We have a question. We have a question that is directly relevant to this. We have a question that asks if your child is receiving special education and the school wants to send them to a school that you don't want them to go to, but you want them to go to another school. Does the school have to listen to our concerns?
So, and this is a phrase which you're going to hear annoyingly often during this presentation, since as we discussed previously, the information that we're offering is meant to be more general in application, but as noted previously, family involvement in decisions as to a child's placement is critical, and you do have a right to participate in those decisions. Now, the specific question of whether you can contest, or perhaps more accurately, would be successfully able to contest a particular placement decision is going to depend on the specifics of the situation. You may want to look at the evaluation data on which the district is trying to base the decision to place a child at that other school, since as again was just noted, your child or grandchild does have the specific right to get their accommodations or get their services in the most integrated environment possible. And Julia, is there anything else that you'd want to provide by way of answer to that question?
I think I would just add, and we'll go into this more, but as Sasanu mentioned, that the decisions are not made by one particular person, but by a team of individuals, as Sasanu outlined, and that in the situation where you are specifically in disagreement with the rest of the team, there are means to remedy or to seek an outside resolution process, as Sasanu mentioned, a TEA, an OCR complaint, a TEA complaint, mediation, and these are if you cannot come to an agreement as a team about placement in the least restrictive environment, these are options.
Thank you, Julia. And also thank you for that question, as this is, in fact, a not uncommon situation that families find themselves confronting. And so I appreciate your getting that issue out on the table for us to address. And one more thing to build on what Julia mentioned, when you find yourself in disagreement with the 504 committee, or as we'll get into a little bit later on, the IEP, or Individualized Education Program committee, never feel like you need to say you agree to something that you don't agree to. It's always important to document the fact that you disagree with a particular decision, because saying that you agree to something that you don't makes it more difficult later on down the line to argue that the district has made a bad decision or an inappropriate decision. The last priority that I want to flag in the area of Section 504 plan development is the right to a manifestation determination review, or MDR. This is another right that comes along with the 504, and that's the right to a hearing before the child is removed from their classroom setting for any significant or long period of time. A manifestation determination review, an MDR hearing, is one at which a committee needs to determine whether the behavior for which the child is being removed from their regular classroom setting is a manifestation of unmet disability-related needs. And in the event that it's found that their behavior was such a manifestation, rather than placing the child elsewhere, they need to make additional modifications in order to ensure that the child's needs are better met. So this is, again, another really important protection that comes along with Section 504. And to reemphasize, you do have the right to take part in 504 committee meetings to the greatest extent to which you feel comfortable. If you find yourself in need of, say, interpretation services in order to meaningfully participate in a 504 committee meeting, you have the right to have an interpreter present. In fact, sometimes 504 meetings will be conducted entirely in the parent's language of preference, if feasible. But again, the right to an interpreter is a critical one. And as noted previously, when possible, it can be very helpful to have the child themselves participate in order to provide their perspective and build their trust in the 504 plan.
So Sanu, another question we have specific to 504. In this day and age of COVID-19, if your child is a virtual home or home learner, are there the services that are supposed to be provided in their 504, are they any different? Should they be any different provided remotely than in person?
That's a great question, and of course, extremely topical. There may be some differences in the specific way a 504 plan is implemented. However, the child does have a right to ensure that, or to have the school work to ensure that they are implementing the 504 to the greatest extent feasible, given the, of course, different nature of remote learning. And to be clear, that doesn't just mean that the 504 plan is going to be diminished or things are going to be taken out of it because of remote learning. In some circumstances, it's appropriate for additional protections or additional forms of support to be added to the 504 plan because of these circumstances. For example, isolation may be having a profound effect upon a child's ability to socialize. which may require additional emotional support accommodations and services. Participating in class can often be much more anxiety-inducing for students when they're doing it via video rather than in person, in which case additional supports may be appropriate there, such as excusing a child from having to speak their answers aloud in front of the class, giving them the option to submit responses via chat. Additional protections may include allowing a child to excuse themselves from video participation entirely when they feel uncomfortable. For instance, if that child experiences severe social anxiety. So that's all to say that while modifications to the 504 plan may be necessary based on just a simple material fact that we're not face-to-face, that doesn't necessarily mean that the 504 plan is diminished. In fact, it may be appropriate for there to be more protections added in.
What I would add to that is that if you are seeing certain the development of new or need for new support, it's important to start monitoring and collecting data on that, because you are a part of the data collection team. If you see that certain scenarios trigger certain responses in your child or grandchild, start monitoring that. And I always tell families, your record keeping can just simply be get a day planner or a calendar where you mark down what you see on those days, or you know, it could be even the same place where you keep your child's doctor's appointments and other therapies. And this will be something that you can present during your next ARD or IEP meeting to discuss additional supports that will be needed, and or whether your child is entitled to compensatory education.
Thanks, Julia. Again, really great question, extremely topical, thank you. And I think we're ready to move to the next slide. Once a 504 plan is developed, it should be implemented as soon as really possible. And its implementation is supposed to be not just with the child's most frequent classroom teacher. Rather, schools are responsible for ensuring that all staff who work with the child are made aware of the 504 plan, how to implement it, and also receive any additional training or resources that they might need in order to implement it. It is no excuse for a school to say, well, our teachers just aren't that well trained in trauma-informed conflict management strategies. If that's what your child needs, it is their legal obligation to provide their teachers with that form of additional professional development. Review of the 504 plan must take place periodically. Now, this timeline isn't well fixed legally. Generally speaking, it does end up taking place on an annual basis. However, you can request that the 504 plan be revisited and revised more frequently, depending on what you observe. So if you notice, as Julia was saying, new tendencies developing, or if you notice that the 504 plan as it's being implemented isn't adequately meeting your child's or your grandchild's existing needs, you can request that the 504 committee reconvene in order to address those concerns. You don't have to wait for a year to pass by. And again, we keep returning to this because it's really important to know that these tools are out there. If you have reason to believe the plan's not being implemented effectively, it's not being reviewed, and the district is not responding reasonably to your requests to remedy these, or to your attempts to remedy these issues directly with them, you can again file a complaint with the TEA. You can request that they provide mediation. You can request that a due process hearing be held in order to determine whether your child's rights have been violated and meet an appropriate response, or you can file an administrative complaint with the federal government, the Department of Education. Again, these are all forms of advocacy for your grandchild where you may want to pursue legal assistance. The second law that we want to explore that you can leverage on behalf of your grandchild in order to help protect their rights is the Individuals with Disabilities Education Act, or IDEA for short. The purpose of IDEA, much like the purpose of 504, is to ensure that every child, regardless of their disability, gets the services they need to have a free, appropriate public education, services that can be academic, social, emotional, or otherwise in nature. Now, IDEA is, it should be noted, narrower in scope than Section 504. It only applies to children who have certain qualifying disabilities which fall into certain specific categories. And Julia, can we actually take one step back, please? It's rather a long list, and so rattling it off from memory is always a little touch and go.
Just a second, sorry. I have a lot of screens open right now trying to manage questions too.
Great, thanks, Julia. The federal law, IDEA, defines qualifying disabilities or children with qualifying disabilities as those who have intellectual disabilities, hearing impairments, speech or language or visual impairments, serious emotional disturbances, orthopedic impairments, autism, traumatic brain injuries or TBIs, other health impairments or specific learning disabilities. And those last two categories I really want to emphasize because they tend to be quite broad and can encompass a lot of different forms of disability that aren't necessarily included in those previous categories, who by reason thereof need special education and related services. So again, Section 504 is a little broader. IDEA is a little more specific in terms of who it covers. And again, grandparents can become involved in this process in three ways. If they have managing conservatorship over the grandchild, if they have a power of attorney, either general or an education-specific power of attorney over the grandchild, or if they qualify as an individual acting in the place of a biological or adoptive parent with whom the child lives, or one who's legally responsible for that child's welfare. Identification under IDEA works much like identification under Section 504. It is the responsibility of the school district to engage in this process called child find. Now, if you want to go ahead and request evaluation under IDEA, much like with Section 504, you can do so, and we recommend you do it in writing, but you should not have to. Your grandchild's school district should be keeping a lookout specifically to ensure that they're not letting children with disabilities go underserved. We also want to emphasize, this is a common area of misunderstanding, that a child who already has a 504 plan can be eligible to get special education services under IDEA. These two laws and the protections that they provide are not mutually exclusive. Generally speaking, a child can be receiving accommodations under Section 504 and start to be considered for services under IDEA. In fact, it's very commonplace for that to happen, especially as Section 504 can sometimes get a child help a little bit quicker, whereas the IDEA process can take a little longer.
Just to add, that's not to say that if your child has a 504 plan, that they can't maybe need more services that would require a transition to an IEP, as the senator said, but also it's also important to note that frequently what will happen is, say your child is on a 504 plan, they are found eligible for special education, and then they're dismissed from their 504 plan. The reason that frequently happens is because IDEA is much more comprehensive. And so anything that can be provided in a 504 can also be provided in an IEP with more protections. And so if that happens, as long as everything that was in the 504 plan that's still relevant is moved into the IEP, it's okay to just have the IEP instead of the IEP and the 504. It's just a little bit more streamlined and comes with more protection. So if you see that happening, don't automatically think that the district is trying to strip your child of any rights. It may just be simpler to move it under into the IEP and comes with greater protections for you and your child.
Great, thank you for clarifying that, Julia. And I think we can move to the next slide.
Give me 1 second, sorry.
No problem. So once a school district's identified a child as being potentially eligible for services under IDEA, they must act within a reasonable span of time, and I'll go into what exactly that looks like in a moment, to get the consent of the child's family to begin what's called the Full Individual Evaluation, or FIE. Now, once a district gets your consent to start the FIE, the IDEA, the federal law, requires that it be completed within 60 days. However, Texas law requires that the FIE, and this is the law that really controls in our circumstances, be completed within 45 school days of getting consent. So to break down the timeline in a bit more detail, if you've requested an FIE, if you've requested that your child be evaluated for special education services, the district has 15 school days to respond to your request. And again, this is another good reason to do this in writing, so you can prove when you made the request in case things later become contentious. If the district accepts and agrees with your request for evaluation, then they have 45 school days to complete the evaluation process. And if they're evaluating your grandchild from multiple needs, they have to get all of those evaluations done within the 45 days. So if they're evaluating them, say, for emotional disturbance, occupational therapy needs, and speech therapy, it's not 45 days for each, it's 45 days for all of those. If they refuse your request for an FIE, they must provide you with a written explanation of the reason why they're denying that request. They cannot simply reject it out of hand. And if they refuse, as we've mentioned previously, those same administrative remedies are available. Now, the FIE, much like the 504 evaluation, needs to meet certain basic criteria. It needs to be conducted using assessments that are tailored to the specific area of suspected disability of your child. In addition, the Individuals with Disabilities Education Act emphasizes the importance of administering the evaluation in a culturally competent way, so as to avoid racial or linguistic discrimination. And so, to pick up this thread again, the availability of interpretation is incredibly important. And not just interpretation, but if necessary, conducting the evaluation in whatever language is necessary in order to accurately assess your grandchild's needs. So if your grandchild's primary language is Spanish, their evaluations should be conducted in Spanish. If their primary language is anything else other than English, then the district has an obligation to, whenever reasonably possible, to conduct those evaluations in that language. Because otherwise, the data that they get from those evaluations is not actually going to speak to your grandchild's potential disabilities. It will instead capture the fact that they are a non-native English speaker.
Another interesting way to look at that, and just to add on to what Susani was saying, if your child is a primary English speaker, but you are a primary Spanish speaker, and your child's home language, therefore, is Spanish, you can also specifically request a bilingual evaluator, somebody who can move back and forth between two languages, just as they would, your child would in the academic and home setting.
And to build on that further, we really do want to emphasize that the federal law requires not just that FIEs be conducted in appropriate languages, but they be conducted in ways that are culturally competent, which means that if, for instance, there are certain elements of your grandchild's cultural upbringing and background that would inflect the way in which they respond to the evaluation, they need to take that into account, even if that goes above and beyond simply conducting the evaluation in a certain language. The general idea here is that districts have an obligation to address every factor that they can be aware of that may get in the way of the evaluation process, providing useful data about your child's disability. So again, the district has 45 school days to complete the FIE. And once they do have the FIE finished, they need to produce a written report of their findings and share it with you. And again, to reemphasize, that report needs to be in an appropriate language. The district then must convene an admission review and dismissal, or ARD, committee meeting to decide whether those findings indicate that the child is eligible to get special education services through what's called an individualized education program, or IEP. Much like a 504 committee, an ARD committee must include parents, teachers, special education professionals, any other individuals who have relevant knowledge or expertise. And if you're a grandparent raising a grandchild, that means you. And again, much like with the 504 process, the more the child can be included, the more effective the ARD committee's meeting will be, the more effective the IEP that gets developed will be.
I also wanted to add that it's really important to know that you can bring anybody that you want to an ARD. My favorite story ever is I did have a client who had been feeling really intimidated for a long time and getting the assistance that her child needed. And so she was sitting there with all these, specialists with titles behind their name and before their name and feeling very talked at. And so at the next ARD, she brought 6 of her cousins. And I asked, what are they going to talk about? She says, they're not. They're just going to sit behind me so that I have as big of a team on my side as they do. And they said nothing during the ARD, but it gave her a lot of confidence. And I thought that was important.
I think that's a really great example because it's real. These meetings can be scary. And if you do ever feel intimidated in them, you should know that that's not you. That's sort of the nature of the thing, that it can be quite intimidating. And there's nothing to feel bad about. And you should feel comfortable bringing in whoever you need, whether it's a friend, whether it's another family member, whoever you need, even if not to actually help advocate, simply to provide emotional support during these meetings. Now, if you disagree with the evaluation results, you have the right to request an independent educational evaluation, or IEE, by an unaffiliated professional at the school district's expense. So this is not someone who works for the district. This is someone outside of the district. The district must respond to this request without unnecessary delay. And if this request is denied, actually to clarify this last bullet, as Julia recently clarified this to me, the district can't simply deny it out of hand. If you request an IEE and they don't want to give it, they have to themselves go through a due process proceeding in order to legally deny it to you.
And in that process, they have to defend the evaluation that the school district conducted and show how it adequately meets the standards set forth in federal law.
And again, to bring this back up, all of these same administrative remedies that we've been talking about are available if you feel that your child's rights, that your grandchild's rights have been violated. State complaint, mediation, due process hearing, or a federal complaint. IDEA requires that the IEP be put together with the participation of that whole committee that we talked about before, and that whenever possible, it be composed by mutual agreement. If you do not agree with what the committee with what the rest of the committee has decided at the end of the meeting, say so. You do not have to sign and to say that you consent to something that you don't consent to under any circumstances. IDEA requires that the IEP be developed with consideration to the child's strengths and weaknesses, family's concerns, the results of the evaluation process, and be reasonably calculated to ensure that they make progress appropriate in light of their circumstances. Now, the word reasonable is one that lawyers tend to use a lot, annoyingly so, since, as you can imagine, there are often heated arguments as to exactly what is reasonable in a particular set of circumstances. But the essential thing to take away here is that if, when you look at the evaluation results and the data, either year over year or within a particular school year, and your child, your grandchild, is not making progress towards the goals that are identified in the IEP, that is a sign that something needs to be changed. Not just in a general what's best for the child sense, but in a legal sense. If they are not moving towards the goals established as reasonable in their IEP within a single academic year, and when we say progress, it has to be more than the absolute minimum, then that's a sign that the IEP needs to be revised in order to better support them. Now, if you get to the end of that ARD committee meeting and there's not mutual agreement about what to do next, oh, actually, I see we have a question.
Just a second. Okay, so this is from an anonymous attendee, and just I guess I'm going to kind of generalize the question since it seems to be a little specific. So if a child who has a disability and does have an IEP is being refused access to extracurricular activities, what would be some option or some remedies that child could pursue, or the child's family?
So, and returning to that time-worn lawyer's phrase of "it depends." So, generally speaking, the first step that we always recommend is trying to deal with the district directly and explaining in writing, here is the extracurricular that I want my grandchild to be in, and demanding that they provide an actual explanation for why they're making the denial, as to whether it's a particular point of that was in the child's IEP that seems in the school's estimation to make it inappropriate to have them participate in that extracurricular, or some other consideration. If they're denying the child the opportunity to do something based on their disability, you have a right to know why, and to participate in that decision. Now, that doesn't necessarily mean that you have the right to change that decision, because it is entirely possible, depending on the circumstances, that there may be a legitimate justification. But as a general rule of thumb, simply saying the child has a disability, therefore they can't do anything more than the bare minimum curriculum. And again, there are some circumstances, but as a general rule of thumb, probably not enough to fly. They need to provide a more tailored explanation as to why that child's specific disability means they can't participate in that specific extracurricular activity. We live in a society that is in many ways very ableist, where a person who is seen as disabled is given that label, is often seen as, of course, as we all know, less than, when in a very generalized way as well. And simply stereotyping a child with a disability as being unable to do more than the bare minimum is not enough. District needs to give some rationale that's tailored to your specific child.
And if they're attempting to give explanation that identifies reasons that are really just proxies for disabilities, so like behavior, when behaviors are a manifestation of your child's disability, or struggling with grades when IEP is specifically focusing on grades, those can be considered discrimination based on disability. Again, it's very, like Sasanu said, very situation dependent, and would require a lot more tailored legal advice, which we're not giving today. So in those situations, it's really important. It is sort of a legal analysis that in order to determine whether there is a legitimate reason for denying the opportunity to participate.
Or a rational basis, as I believe the standard would be in cases like this. But thank you for that question. Do we have another question in the Q&A there? Or is that the same one?
It's just a follow-up. So yeah, but no, you can keep going. Thanks.
Okay, great. We'll keep rolling then. If at the end of the ARD committee meeting, mutual agreement isn't reached, so you've worked together as a committee to talk about what should be in your grandchild's IEP, but you just haven't met minds on that question, you have the opportunity to recess the committee for a period not to exceed 10 school days. And during that period, the committee has to gather additional information and review provisions of the proposed IEP to see if some modifications can be potentially reached to get the committee to consensus. But if upon reconvening and taking those 10 days to think things back over, the committee still can't reach consensus, the school is supposed to implement the IEP that it has deemed appropriate, but to document that you disagree and the reasons why you have disagreed. And this is, again, part of why it's really important to never say yes to something that you don't want to say yes to. Sometimes, again, it can be really intimidating and you can feel pressure just to say yes because all these people with alphabet soup after their names are telling you that what's in the IEP is appropriate, even though you know in your gut that it doesn't meet your grandchild's needs. And this is part of why it is so important to bring support sometimes. But do your best to try and resist that pressure because registering that disagreement can be very important later on if you do try and seek these outside remedies that we've talked about. A child with an IEP has the right to get the services that it describes. These may include the kind of accommodations that we discussed in the 504 plan. So those can be academic, things like getting extra time on assessments, or the opportunity to take them in different settings that are distraction-free. They may include things like getting access to counseling. They may include things like specialized behavior plans that help your grandchild manage their emotions in more healthy and productive ways. However, IEPs often provide more elaborate and robust systems of support than 504 plans. They can include things sometimes like one-on-one support from a paraprofessional and related services like speech therapy, occupational therapy, and physical therapy, all targeted to making sure that your grandchild can participate as much as possible in their schooling. They also have the same procedural right to that manifestation determination review, or MDR, before any major change in placement, like suspending them from school, for example, from an extended period of time. And again, if you have reason to believe the districts fail to comply with these requirements, those same administrative solutions are available: a state complaint, mediation, due process hearing, or a federal complaint. Once the IEP is finished, the school is again supposed to implement it as soon as possible. It needs to be reviewed at least once a year by that ARD committee to determine if your grandchild's making progress towards their goals. But you can also, again, request more frequent review if concerns arise or there's going to be a change in the child's placement. And again, if the child is not making progress towards their annual goals, the committee has the obligation to revisit the plan to make sure that they get the additional support that they need. And as with the original drafting, these amendments need to be made by consensus. And one last time, if you have reason to believe that the district's falling down on the job, not meeting these requirements, you can file a state complaint, request mediation, request a hearing, or file a federal complaint. All services with which attorneys can help. We are very glad to have had the opportunity to share this information with you all so that you can better use Section 504 and the Individuals with Disabilities Education Act to advocate for your grandchildren's education rights. My name is Sisinu Aldemariam. My managing attorney, Julia Longoria. I've been really glad to speak with you today, and our contact information is contained here.
Thank you, Sisenu, and thank you to all of you for your time. And we are putting our information up here to see if you are, if you need help and want to see if you are eligible for our services. There are also other wonderful organizations who do this kind of law, including Disability Rights Texas. There are private attorneys in the area who also do this area of law, and several legal clinics through the law school. So thank you all again, and we appreciate your time.
Thank you, Susan, and thank you, Julia. I want to leave open just a few more minutes. Does anybody have any more questions that they would like to ask? Please add them to the question and answer. Okay, I have not seen any more questions. Once again, thank you for your presentation. It was really helpful. And it's going to be a really good segue in some ways to the next presentation, which is about public benefits, including SSI, which is disability insurance. So please hold on. We will start our next session right at noon. So we'll take a break, give everybody a second to get another cup of coffee or a drink of healthy water if you're prone to do that instead. And we will start again right at noon. Thank you again.
I saw we had a raised hand. If that was that a question? I believe it said Maria. Or my eyes could be playing tricks on me.
Hello, everybody. My name is Renee Trevino, once again from Texas Rio Grande Legal Aid. A couple of ground rules or just some basic housekeeping you want to take care of before we start the next presentation. All of the presentations today are meant for legal education, for knowledge. We are not giving any specific or tailored legal advice today. There are going to be, and throughout the presentations, we've seen different ways in which you can reach out to organizations such as TRLA, such as SALSA, to request legal representation if you believe you're eligible for our services. And we're also going to let you know of other legal resources that are available. Also presenting with me today is Anna Holdren, who is an attorney from our Corpus Christi office. And what we are going to be discussing today, oops, I already went on the slide too many. So I would ask if anybody has questions, go ahead and put them in the Q&A, and I'd be happy to answer them as we go. So now I'm going to share my screen. If I can do this properly, there it is. All right. Now let's see. All right. So what we're going to be talking today about will be benefits, government benefits that are available to non-parental caregivers. The first thing I want to start off with is there's so many misconceptions about what government benefits are. And so I want to remind everybody that government benefits support education, things like public schools, universities, scholarships, fellowships, supports businesses in our community with tax incentives and tax breaks. But also what we're talking about today are government benefits that support healthy families and children, in particular cash assistance, nutritional benefits, and healthcare benefits. And then also we're going to be talking about government benefits that support people with disabilities. One of the things that is very important in discussing government benefits would be what the federal poverty level is, what the FPL is. And so when I talk about poverty guidelines, that is what I'm talking about, federal poverty level. And I wanted to give you an example. 100% of the federal poverty guidelines in 2021 for a family of 4 would be $26,200 a year. At 200%, it'd be $52,400 for a family of 4. Most of the government benefits I'm going to be speaking about today are need-based benefits, something that Carol Bertsch in our first presentation called it means-tested public benefits. And what a need-based benefit is, or a means-tested public benefit is, it's a benefit that in order for a person to be eligible to receive the benefit, they're going to look at either income and or financial resources. So some of the benefits I'm talking about today, most of them actually, will be need-based or means-tested public benefits where income will matter. Financial resources or assets will matter. One of the other things about the FPL, I get a response oftentimes by, we don't fit into your financial guidelines, for example, because Texas Rio Grande Legal Aid also uses the FPL to determine who we can represent. It is an outdated notion in many ways, most economists believe that. It's based on a 1960s assumption that the cost of food accounts for 1/3 of household spending. And of course, we know with childcare and transportation and all the other expenses that families face today, that this is just really not true. But it is what we have to work with. That's the framework for benefits if they're need-based. If you walk away today not remembering anything else about benefits, what I want you to remember is apply for benefits. See if you and your family are eligible for these benefits. Part of that is you have to make sure when you apply and when you receive benefits, you have to make sure you report in a timely manner to the agency giving you benefits any changes in household composition and membership, income, and financial resources or assets. And then also, if you apply for benefits and you're denied, please remember you have the right to appeal. And we'll discuss all 3 of these things through this presentation. Now, what I want to start off with is when you apply for or receive any type of government benefit, you have some very basic rights. And I'm just touching on the most important 3 rights. First of all, if you believe that you may be entitled for a benefit, you are guaranteed the right to apply for benefits first time you ask for assistance. If you go to Texas Health and Human Services Commission and say, I need help, they have to give you an application. So you don't have to ask for application, they have to give you an application. You should ask for it, of course. But at minimum, the first time you request help, you should get an application, and you should be given an opportunity to complete the application and to file it. One of the most important things we have to stress is unless you have an active application for benefits, you have none of the other rights. So make sure you have an active application for benefits. On the application, something else that's very important, they are long. Health and Human Services Commission application is over 14 pages long. But in order to file an application, all here is for it to have your name, your signature, the date of application, and a mailing address. Those 4 things are absolutely essential. Now, the reason I say this, because these applications are long, the date of the application in most instances is going to be the first date that you're going to be able to receive benefits if you're eventually determined to be eligible for them. So the date of application is important. File your application as soon as you can. Fill it out as fully as you can when you turn it in. But if you are missing information, you're missing documents that are going to be required, go ahead and file it, because it is incumbent upon the agency, whether it be Texas Health and Human Services Commission or Social Security Administration, to send you a letter that says if information or documents are missing in order to complete your application. And they have to give you at least 10 days to submit that additional information or the documents they're requiring. So once again, application date is important. Now, once you file an application, you have the right to receive a written decision on your application. The agency must tell you if your application is granted, denied, or if more information is needed in writing. They can't just say, no, you're not eligible. They can't tell you that over the phone. They can't tell you that in person. They have to give you a written decision. If they do not give you one, demand one. And when there is information missing on your application, the agency must give you a clear, specific statement about what information is missing and what documents are missing to complete your application. Finally, if an agency denies your application, they must, once again, provide in writing the reason for the denial, your rights to appeal, and how to appeal. Anna, do we have something?
Yes, we have a question. And I don't know if you want to address it later. Can you hear me?
No, go ahead. Go ahead next.
Okay. Is there a child-only Medicaid? I was told they won't go off grandparents' income.
Actually, that's one of the things that we're going to talk about next. So we're going to talk about the basic, I want to give you a little bit of framework. We're going to talk about the benefits that are most easily and are usually accessed by grandparents to care for grandchildren, and Medicaid will be one of those benefits. I just want to touch really quickly on immigrants and what immigrants are eligible for benefits. There's always a lot about this in the news. The first thing I want to say is, regardless of the citizenship status of the parent or caregivers of a child, if the child is a United States citizen, that child is entitled to all of the same rights and benefits as every other citizen in the United States. It doesn't matter if a parent is undocumented, a grandparent is undocumented, a citizen child is entitled to all the same rights as any other citizen in the United States. And legal permanent residents and immigrant children also have rights that are enforceable through the law. I'm not going to go into all the little details about immigrant eligibility for benefits. The important thing to understand is if somebody's undocumented, they really are not eligible for very many of the government benefits I'm going to talk about today. Of course, they are entitled to an education in the school district that they are located. But for the benefits we're going to talk about today, somebody who's undocumented for the most part is not going to be eligible for any type of governmental benefits. A couple of other basics that I'd like to cover before I get into the specific benefits. If you are working on an application or are receiving benefits from a governmental agency, there are very important requirements as far as when you report changes. What changes are going to need to be reported? You're going to need to report changes in who lives in your household. You're going to have to report any changes in income, whether it's earned income from employment or other forms of income that you receive. You're going to have to report changes in your financial assets, or what in public benefits law we call resources. So those are very, very important things that you have to report, and you have to report timely. Both for Health and Human Services Commission and the Social Security Administration, the rule is that you have to make these report of changes within 10 days of when the change occurs. So for example, if you start working, you don't have to report when you start working. You have to report when you receive your first check. For the different agencies, and I am focusing today on Health and Human Services Commission and the Social Security Administration, there are forms that you can use to report these changes. Or for the Texas Health and Human Services Commission, you can call 211 and be connected to the Health and Human Services Commission and be able to make a report of change by telephone. The most important thing to remember, though, is just because you do your job and you report any changes in household composition, income, resources, whatever it might be, it does not mean that the agency is going to properly file away or place that information into your file. So it's very important for you to keep copies, get a receipt when you submit it, keep copies. If you fax it in, keep a copy of the fax cover sheet. If you're going to mail it in, if you can do it, I know it's expensive, try sending it certified mail with a return receipt requested, that's the green card. Do what you can to document when you do report these changes. Keep a calendar, just your regular day minder calendar where you keep all your doctor's appointments and other appointments. Keep track of who you spoke to, when you spoke to them, and what was said on your calendar. That is very important also. So need-based benefits, or as Carol called them earlier, mean-tested public benefits, also look at financial resources. And so I just want to let
into resources. We do have
yes
a question about that that time frame of submitting a report of change. What happens if you miss that 10-day window?
If you miss the 10-day window, it's not catastrophic. That is what the law is, and you should try to meet that. Now, if you miss it and you get the information to them within 30 days, even maybe within 60 days, you're still okay. But if you don't report and it's been 2 years or 6 months even, that's getting a little bit more serious. The important thing is for you to report as soon as possible. If you haven't reported yet, you're going to need to report. It may affect, the reason it's important to report these changes is because those are the type of changes that can affect what benefits you're eligible for. And if you receive benefits for which you're not eligible, the government gets their money back. And so you don't want to create a problem about an overpayment.
And there's another question. I'm not entirely sure if I understand. So if it's not quite clear, it's from Shelley, and if Shelley could just clarify if we don't quite understand. Can they count the adopted money the kids get every month?
Oh, oftentimes with foster children or adopted children, there are subsidies for the adoptive parent. I'm assuming that's what is being asked about right now. And it depends on the benefit. One of the things that you're going to see in the next few slides is that each program has different rules as far as income and what counts as income when determining eligibility or the level of eligibility. So it depends on each specific program. I don't know right off the top of my head. It is definitely something you need to report and then let the agency sort through it. That's the best answer to that question, I think. Okay, so financial resources. What are financial resources? Your homestead never counts as a resource. However, any other property you own may be counted as a financial resource. Things like burial insurance and plots and plans and things like that, some of those do count for some programs. Life insurance policies, there's a couple of different types of life insurance policies. One is nobody gets anything until you die. Those policies don't affect any of your benefits. The policies, insurance policies that may affect your public benefits are the ones in which they're whole life insurance policies is a lot of them what they're called. They're ones that have cash value. They're the insurance policies that you can borrow against. They're the insurance policies that you can cash out. Those oftentimes are counted as a financial resource. Government payments, VA benefits, Social Security benefits, things like that do count in most circumstances for benefits. And vehicles, the first family vehicle never counts as a resource for anything except SNAP benefits. But you just need to report what vehicles you own, what year they are, if they're running, if they're not running, things like that. All right, so now I'm going to talk about the Texas Health and Human Services Commission. I think we're going to be able to answer that question about Medicaid. Now, for all the programs that the Texas Health and Human Services Commission are responsible for determining eligibility and making sure that they're distributed properly, there's something called the Eligibility Determination Group. Really, that's just who's in your household. And it's the members of the household who needs resources and income and deductions are considered to determine eligibility for benefits. So a household is who lives in the home. And so there may be people in the home that are not going to be eligible for benefits, but you always need to report all the income from every household member and all the financial assets of every household member to make sure that you're covering yourself and your family. And then the agency will make a determination of if they're household members who are not qualified for benefits or whose income and resources don't count to determine eligibility. But just once again, make sure you report everybody who's living in the household and you report everybody's income and everybody's financial resources. Now, SNAP. SNAP is what used to be called food stamps. It's a supplemental nutrition assistance program. It's a nutrition assistance program. It helps buy food. It's distributed on the Lone Star card or the My Texas Benefits card. It looks like a little debit card. SNAP benefits take into account the income and resources of all family members, all people in the household. And so it's people who live together and buy and prepare food together is the definition of who's in the SNAP household. Now, for grandparents rearing grandchildren, sometimes this can be a problem because if, for example, you're working and earning money, or if you're on Social Security retirement already, that income is going to count for eligibility for the household for SNAP. And so grandparents' income will count when determining whether or not a household is eligible for SNAP. TANF is cash assistance. Now with TANF, that's kind of what people traditionally think of as welfare. It's also dispersed on the Lone Star card. It can be used not just for food because the SNAP only pays for food. It doesn't pay for diapers. It doesn't pay for toiletries. It doesn't pay for anything like that. It only pays for food. The TANF benefit, that cash benefit, if you are low income enough to receive it, that benefit you can use for things like diapers or for toiletries and hygiene care issues or things, or for other bills that you need to pay. Now, when you're talking about TANF, only the child's income counts. If the child is not living with their parents and is living with a grandparent or other non-parental caregiver, then only the income of the child counts. Now, income of the child could be child support. It could be benefits from Social Security. It could be other types of benefits, but only the income of the child counts, not the grandparent's income, to determine if a child is eligible for TANF. Medicaid is like TANF. Only the child's income is eligible or counts towards eligibility. So the answer to the question that I asked earlier is yes, many, many children will be eligible for Medicaid when they're living with their grandparents because their grandparents' income will not be counted as income to determine eligibility for Medicaid, only the child's.
And Do foster children or foster grandchildren count for the purposes of eligibility for a SNAP household?
I believe yes. The safe answer to that is you've got to report that they live in the household. And you have to report if you're getting money. There's the subsidies, once again, for foster children. So those subsidies, you want to make sure you're reporting them. I don't know the answer to that question right off the top of my head. I apologize for that. But the most important thing is report the income, let the agency do the evaluation. That way you do not run into problems later. All right, so a little bit more about SNAP, nutrition assistance. Who is a non-parental caregiver? This is important. It all is based on what's termed parental control. So when a minor is living, or somebody under age 18 is living with an adult and is under the parental control, if the following conditions apply. The adult provides more than half of that minor's total support. So you have to be giving financial support. And just living in the household is not financial support. It's actually providing food, clothing, all those other things also. The adult states that he or she has parental control of the minor, or the minor lives with an adult other than the minor's parents or legal guardian, and that the minor's parent or legal guardian says grandma has parental control of the child. All right, that's for SNAP benefits. It's a little bit different for TANF. TANF is the cash assistance, and also this is going to apply if a child is eligible for TANF, they're automatically going to be eligible for Medicaid. So think about this for Medicaid also. And when you're dealing with TANF, temporary assistance for needy children, the cash benefits, and it's called a caretaker. So the question is, who is the caretaker? The caretaker is any relative who is present in the home and supervises and cares for the TANF eligible children. To be a caretaker for TANF, you have to be the father or mother, the grandparent, the sibling, so the brother or sister, the aunt or uncle, the first cousin, nephew or niece, stepfather, stepmother, stepbrother, stepsister, first cousin once removed. The most important thing is you need to be a blood relative or a step relative. That's really the key to being a caregiver when receiving TANF. And once again, remember, if the child's eligible for TANF, they're automatically eligible for Medicaid as well. Once again, caretaker relationship matters in TANF. Not just the blood relative, but the relationship extends to the spouse of a relative. Also, for grandparents, we do see this. We see great-grandmas and great-great-grandmas or grandparents taking care of grandchildren. So the caretaker relationship extends to them as well. It goes to great-great-great-grandparents. Now, something else. So even if a court has jurisdiction over a child or an agency is a managing conservator for a child, you can still meet the definition of caretaker for TANF if you're the parent, the non-parental caregiver who is there for the child and the child lives with. And those are instances of foster children who are under CPS control or Department of DFPS. Anyway, but for the CPS, Child Protective Services, or court's jurisdiction over a child, you can still be the caretaker for TANF benefits. The other thing is, if you are managing conservator, meaning you have filed a suit affecting parent-child relationship and you have legal custody over a child, you still have to have the relationship. You still have to be the blood relative or the spouse of a blood relative. Going on with Texas Health and Human Services Commission, I wanted to give a really concrete example of a grandparent household because it can be a little bit weird. Say you have one grandparent, two grandchildren, and a half sibling to the grandchildren living with the grandparent. That would be a situation where let's say the grandparent's child, the adult who has these children, had two children of her own, and then she was taking care of her partner's child, who's not her biological child, but she's taking care of a third child, and the grandparent takes all these children in together. What will happen? For SNAP, the grandparent has parental control because they're the head of the household. All members in the household, the grandchildren and the half-sibling to the grandchildren, will be considered part of the household, and all income and resources in the household will be counted. So any child support any of those children are receiving, any Social Security benefits any of those children might be receiving, as well as the income and resources of the grandparent will be considered to determine eligibility. Now, the two grandchildren, assuming that they don't have any income or they have very limited income, they would probably be able to be certified for TANF because they're living with a blood relative. And you only count the children, the individual child's income and resources for determining eligibility for TANF. And they'll be eligible for Medicaid. And I put TP08 there, that's just basic low income children Medicaid. Now, if you don't know, there are many other types of Medicaid that are available for children with special needs, with disabilities. So we also at TRLA represent people who are having problems with those special need Medicaid programs. I'm not going to delve in them today, but I did want to let you know that Texas Rio Grande Legal Aid does represent children who are having problems with Medicaid that's given to them specifically because of disabilities. But the two grandchildren have that necessary degree of relationship to grandma to be able to get TANF and Medicaid without counting grandma's income. The half-sibling who doesn't have the blood relationship to the caretaker grandmother will not be certified as part of the household for TANF and Medicaid, but may be eligible to be certified as their own household. The term household, when you're dealing with benefits, has a very specific meaning for each one of the benefits. So the definition of household for a SNAP household is different than the definition of household for a TANF household or a Medicaid household, just to make things a little bit more confusing.
And I did pull up the regulations quickly since we're talking about households, and it does look like foster parents are generally considered, if the child has been placed in foster care by DFPS, to have parental control over their foster child for the purposes of SNAP applications.
Okay, but what about the subsidy for foster care that may be paid to the caregiver?
That I did not look up. I just looked up whether or not parental control was allowed.
Well, thank you. Thank you for looking for that. All right, so let's go on. We're going to skip off Texas Health and Human Services Commission. If you have any questions, let us know. We'll go back and answer those questions, but I want to move forward to benefits through the Department of Veterans Affairs, or VA. A grandparent is a veteran, and they want to see if the grandchildren may be eligible for any type of benefits as dependents of the grandparent. Unfortunately, the answer is no, unless the child is legally adopted. When a child is legally adopted, that means that regardless of what the real blood relationship is, they become the legal child of the person who adopts them. And in that case, then yes, that child would be counted as a dependent for service-connected disability compensation or for VA pension, and even as a survivor of a deceased veteran under the DIC program, which is Dependency and Indemnity Compensation, where a veteran dies of service-connected disabilities. That type of survivor's benefit could flow to a child, but only if they are the legal child of the veteran. So I'm afraid I don't have good news on the veteran front for grandparents. Now, next, I'm going to skip over now to the Social Security Administration. Now, the Social Security Administration, the important thing to remember about Social Security is there are two sides of the house. One side of the house is SSI, or Supplemental Security Income. That is a need-based program. That is a means-tested public benefit. So anybody's income or resources, the financial assets, are going to make a difference in whether or not they're eligible for SSI. And generally, children are eligible for SSI if they're disabled. But we'll talk a little bit more about that in a minute. The other side of the house is this RSDI, Retirement Survivors Disability Insurance. Usually RSDI is, there are 3 separate programs, just to make it confusing, under RSDI. But aside from that, the benefits under RSDI, they're all based on a wage earner, somebody who has worked and contributed to the Social Security system. So usually the people who receive the disability insurance part of retirement survivors and disability insurance, they're going to be adults, usually not children. But I will talk about how dependent children may be able to get RSDI. And then of course, also under Social Security is Medicare. Always remember, Medicaid is managed by the Texas Health and Human Services Commission. Medicare is managed by the Social Security Administration. And if you don't know which one you have, all you have to do is look at your insurance cards. If it's a Medicaid insurance that you have, because that's what Medicaid and Medicare are, they're just government funded insurance programs. If it's a Medicaid program, you're going to have a white card that says My Texas Benefits, and it's going to have an emblem of the state of Texas and the Texas Health and Human Services Commission on it. If you're receiving Medicare, you're going to have some version of a red, white, and blue insurance card that says Medicare. So that's how you know if you have Medicare or Medicaid. And of course, you may have both. So just in case, you know you can have both in limited situations. All right, so this is meant to help people understand the difference between SSI and Social Security Disability Insurance. SSI, like I said, is on one side of the house. Social Security Disability Insurance is under that RSDI header. SSI, they're both disability benefits. And disability, of course, is defined by Social Security, and we're going to talk a little bit about that in a minute. But first of all, you have to meet Social Security's definition of disability for both SSI and for disability insurance. The differences come in that SSI is a need-based benefit, so income and resources do count and determine eligibility. Even if you're disabled, you might not be eligible for SSI if you have income or resources that are too high. SSI always comes with Medicaid, so you'll have that My Texas Benefits card with the Health and Human Services Commission and the Texas seal on it. There are maximum benefits that a person can receive when they're receiving SSI. SSI in 2021, an individual, the maximum benefit they can receive is $794, or if it's a couple, they can receive up to $1,191 a month in SSI benefits. And another way to know if you're getting SSI or if you're getting disability insurance, SSI is always paid on the first of the month. And disability insurance is either going to be paid on the 3rd of the month or a 2nd or 3rd or 4th Wednesday of the month. So that's another way you can tell if which one you're getting. As I said earlier, disability insurance is based on somebody having worked and contributed to the Social Security system. And then also there's a 10-year look back. So the work is not just work over your lifetime. You have to show that you worked and earned money at least 5 of the years prior to becoming disabled. And then disability insurance comes with Medicare. Now, a little bit more about SSI. When I say it's a need-based benefit or a means-tested public benefit, you have 4 eligibility criteria for supplemental security income. First of all is disability. Disability for Social Security is a very odd thing. It has its own definition, which is specific to the Social Security Administration. It's not that your doctor says you're disabled, it's that Social Security says you're disabled. And it's that you have severe impairments or illnesses or diagnoses that are expected to last at least 12 months or end in death. So it's severe illnesses. And I'm going to talk about the difference for disability when it's a child versus when it's an adult a little bit later on. But that's the basic definition of disability. So you have to prove disability, meeting Social Security standard. You actually have to reside in the United States. That's different than citizenship or immigration status. This is in addition to meeting the citizenship or immigration status required for SSI. You also actually have to live in the United States. Also, there are income guidelines. You cannot have too much income, and too much income is pretty low, to be honest. And if you're dealing with children, you always have to think about deeming of income. Deeming in Social Security language means that the income of a parent for a minor child is considered when determining if the child is financially eligible for SSI. There's also deeming from spouse to spouse, but we're not going to talk about that because we're talking about grandparents and grandchildren today. For resources, there are also pretty strict guidelines. But for children, what happens if the child is disabled? First of all, there's an evaluation of let's say it's a single grandparent rearing the grandchild. If the grandparent has $2,000 or more in financial resources, then that is taken into consideration. And then there's also the question about once you take out another $2,000 for the child, so it's really $4,000, that would make the child. I don't want to go too much into there because we can go really deep in the weeds on those type of things. But if you have any questions, ask and I'll try to answer them for you. And remember, on resources for SSI, homestead, the house in which you live, is always exempt and not counted. And your first automobile never counts, no matter what the value of it is.
So we have a question.
And yes.
If a grandparent adopts a grandchild and receives RSDI, can the grandchild still receive supplemental security income?
It depends. And that's not just a lawyer answer. It depends on what income is received by the grandparent and how that plays into the calculating of income for a child. So I think I'm going to talk about that just in a little bit, but if I don't come back to that, let me know. What is important, if the child is adopted by the grandparent, then the grandparent's income, because the grandparent is now the legal parent of the child, is going to be deemed to the child. So it's not a straightforward, easy calculation. If it's earned income, meaning from employment, but if it's unearned income and it's from Social Security benefits, basically there's a $20 disregard. So they don't count $20 of your income. And then they look at how much money you receive from Social Security. So yes, the income will be counted to determine eligibility, but it might not be disqualifying for the child's SSI. We'd have to take a look at that specific case. I would still recommend applying for SSI for the child. But what I was about to say is, because this is a means tested or needs-based benefit, income, resources, and household composition and residence must be reported in 10 days if they change. SSI who qualifies in 2021, I already gave you the definition: a person with a permanent disability that's expected to last at least 12 continuous months or which is expected to end in death. Adults and children who are disabled may be eligible for SSI. Elderly, folks who receive less than $814 in Social Security retirement or Social Security disability insurance may be eligible for SSI, assuming you also meet the resource guidelines. And we already talked about physically residing in the United States. So next, I'm going to talk about disability insurance. Once again, this is a cash benefit for people who are disabled. There are people who have contributed into the Social Security system, and they have insured status, which means they've worked at least 5 of the 10 years prior to becoming disabled. The big difference between SSI and disability insurance is that you might be able to get more money every month through disability insurance because SSI has that cap. But SSI comes with Medicaid, which pays 100%, and disability insurance comes with Medicare, and you don't get your Medicare for the first 24 months you're determined to be disabled. It's also called a number of different things. I always like to throw in that people call it DIB, Title II, SSDI, but just remember, disability insurance is going to be usually for an adult, who has worked recently in 10 years prior to becoming disabled. Now, the good thing about disability insurance is if the adult is getting disability insurance and they have minor children that they care for, the minor children may receive cash benefits. They won't get medical benefits, so they won't automatically get Medicaid or Medicare, but they will get cash benefits every month. And the children who would be eligible, and I wanted to tailor this specifically to the grandparent audience we have tonight, you have to be the natural, adopted, or stepchild of the grandparent's child. And then the parent, we'll just make it simple, the parent is deceased at the time the grandparent became eligible for RSDI, for the disability insurance. So if you have a situation where you are the grandparent, your child has died, and that is why you're caring for your grandchildren, and your child had died prior to becoming eligible for disability insurance, then your grandchild would be eligible to receive disability insurance dependence benefits. Also, if a grandparent legally adopts a grandchild, then once again, they're the legal child, and so they would be able to get benefits as a dependent of the grandparent. There's something else I want to throw in here as far as dependents. If you're caring for a disabled adult child, so somebody who's over 18 years old, but that was disabled prior to turning age 22, those adult children may also be eligible for dependence benefits. And then also spouses, of course. And just remember, the amount of benefits the dependent's going to receive is not going to take away from the disabled person's disability insurance benefits. The disability insurance benefits that the individual receives is calculated based on how much you contributed. So that's not going to be affected by you having dependents drawing off of your disability insurance. But the amount that they're going to be eligible to receive will be dependent on how much you had contributed into the Social Security system prior to becoming disabled. Retirement benefits, I just want to touch on it really quickly since we are once again dealing with grandparents. Retirement benefits from Social Security, really straightforward. You worked during your life and you earned you worked at least 10 years or earned 40 quarters of work history with the Social Security Administration. You're going to be entitled to retirement benefits once you reach retirement age. And so the important part here is a retired worker will get benefits, your spouse might get benefits, and the dependents of a retired worker, this is how it works for who gets dependents benefits based on Social Security retirement. It's the same as for disability insurance. If the natural adopted or stepchild of the grandparent's child, so you're the grandparent, child, the parent of your grandchildren, died or became disabled prior to the time the grandparent became disabled and eligible for retirement benefits, or the grandparent legally adopts the grandchild. That's when the grandchild will be eligible for dependence benefits under retirement as well. All right, so survivor's benefits. What survivor's benefits are, most people think of survivor's benefits from the Social Security Administration as being widow's benefits or widower's benefits for a surviving spouse. Spouse dies, you get to receive widow's benefits or widower's benefits, but under Social Security law, it's called survivor's benefits. And survivor's benefits also can cover minor children or adult disabled children may be able to get survivor's benefits based on a worker's death. Now, who's eligible for survivor's benefits? Once again, it's going to be your natural adopted or stepchild. So the grandparent who adopts a child, adopts their grandchild, that grandchild would be eligible for survivor's benefits if you die. Certain adult children, like I said, if they became disabled prior to age 22, they may be eligible for dependents benefits or survivor's benefits, excuse me, if a grandparent dies. The other thing about survivor's benefits, if the reason you as a grandparent are caring for a grandchild is because your child has died, and you need to apply for survivor's benefits for that child based on your child's earnings history. So if your child had worked and paid into the Social Security system, even if it wasn't an enormous amount of work over their lifetime because their life ended early, or they were working low-wage jobs, it's still worth filing the application for survivor's benefits based on your grandchild's parents' earning history. Because that's another way a child can get survivor's benefits. Let's see. So what children are eligible, I'm just gonna go through this one more time, on survivor's benefits from Social Security. If the parent is deceased, surviving child may be eligible under parent's earning history. For a grandchild to be eligible under a grandparent's earning history, either both of the parents have passed away, or both of the parents have died, or one's disabled and one has died, then the grandchild might be eligible for dependents benefits through the grandparent. But if both parents are alive and they're not disabled under Social Security rules, remember we're dealing with Social Security rules here. If both parents are alive or either of the parents are alive and not disabled by Social Security rules, the grandparent will have to adopt the grandchild for the grandchild to get dependents benefits. And remember, survivor's benefits is a monthly check that comes from the Social Security Administration, but it does not come with the health insurance of either Medicaid or Medicare. Do we have any questions, Anna?
No, but I'd like to add that there are some tiny caveats if you were maybe in the process of adopting your grandchild at the time you died, that they might be able to qualify. So just because the adoption wasn't finalized doesn't mean that they might be out of luck. So talk to an attorney.
Yes.
Very
and
specific situation, but I don't want people to think that because it didn't happen that they're done.
Yeah. If you're in the process of getting an adoption over your grandchild and you pass away, or your spouse was in the process of getting or adopting your grandchild, there is a tiny carve out, but it's really specific to the facts of the case. And when Anna says talk to an attorney, when we're talking about public benefits or government benefits, you need to talk to an attorney that knows benefits. Most general probate attorneys or attorneys that do wills, or an attorney that does personal injury work, or even attorneys that do family law, most of them don't know public benefits law. It's a very, if you can't tell already, unique area of the law, and it's full of all kinds of rules, and then there are exceptions to the rules, and there's exceptions to the exceptions to the rules, and there's exceptions to the exceptions to the exceptions to the rules. So if you have one of these really specific questions, you're going to need to talk to an attorney that understands the Social Security system. Now, with Social Security, there's something called a representative payee. And for grandparents caring for grandchildren, I want to make sure that we touch on this. If your grandchild is receiving SSI or any type of disability benefit or any type of benefit, period, from a governmental agency, and then but the parent is receiving the benefit, you've got a problem. If the grandparent is caring for the child, in most instances, the proper person to receive the benefits and is the person that's going to give the care and support to the child. So something you might want to consider if you're caring for a grandchild, you are not the representative payee for that grandchild. You might see if maybe it'd be appropriate for you to be the representative payee. And what a representative payee within the Social Security Administration means, it's a third party who's appointed to manage the benefits of a disabled person who's determined by the Social Security Administration to be unable to manage their own benefits. And of course, children automatically need a representative payee. A child under age 18 will need a representative payee. And it's just a question of who's the most appropriate representative payee. It is a decision that's made by the Social Security Administration. A power of attorney will not function to get you representative payee status. So just remember, representative pay, and you don't have to be the legal parent. You don't have to be the legal guardian. You don't have to have custody in order to be the representative payee of a person for Social Security. And Social Security workers, bless their hearts, they're overworked and underpaid. I personally only deal with them when they've made wrong decisions, and sometimes very wrong, very mean decisions. So forgive me if anybody works for the Social Security Administration, but they give out misinformation all the time. And one of the pieces of misinformation they give out all the time is that you have to get custody or guardianship over a child in order to be the representative payee. And that simply is not true by law. And how you register as representative payee is really simple. You just go to the Social Security Administration. Social Security, there's a form for everything. And if you can go online, you can just Google representative payee, and it'll take you to a section that talks about the responsibilities of being a representative payee and the rules for being a representative payee, as well as how to become a representative payee. I just realized we're running out of time. This is going really fast. Do we have any questions? All right. All right. So Social Security redeterminations. This is Anna's slide. I'm going to tell you this now, and I love it. The 18th birthday gift that nobody wants. For any child who's receiving SSI as a child, the most important thing you have to understand about Social Security SSI rules or disability rules, there's one set of guidelines called the listings that defines each disability that an individual might have. So you have a diagnosis of being blind. The Social Security Administration has their definition of what blind is. And so it's not only the symptoms and the diagnosis, but it's also the limitations caused by that illness that will determine if you're disabled. The reason I bring this up is not to go off into the weeds and talk more about that, but rather to let you know those definitions are different if it's a child up to age 17. Once the child turns 18, the definitions of the disabilities themselves change. Sometimes it's very subtle changes, sometimes it's very big changes. But first of all, the rules to get you to the determination about whether or not you're disabled change when somebody turns 18. The other thing that changes when somebody turns 18 is that the definition of disability goes from whether or not, when you're dealing with a child, you're talking about the whole child. How this whole child compares to other children their age. Are they on level in school? Are they able to socialize and interact with other children their age? So it's age appropriate development and performance. For adults, it's all about working. Are you able to work? Are your disabilities, are your illnesses, your diagnoses, your impairments, whatever you want to call it, severe enough to keep you from working? And so that's a very different standard, especially when you're talking about intellectual or developmental delays. A lot of children who are going to be eligible for SSI before they turn 18 are not going to be eligible for SSI when they turn 18 for illnesses such as ADHD. So just a thought, remember, whole child, how this child compares to other children their age and how far behind other children their age they are versus an adult who the expectation is you're going to be able to work. Some things to talk about when a child's turning 18. Anna, do you want to take over from here?
Sure, I absolutely can. So the reason that I have done some of these redetermination slides is because I'm also a guardianship certified attorney. So I see a lot of cases where kiddos come to me, they're right about to turn 18 and they are receiving SSI. And so I work in public benefits and guardianship and can speak to some of these considerations pretty easily. So talk with your kid or grandkid about whether or not they feel able to work. I think it's so easy to assume that they want to pursue adult disability, and a lot of kids want to work, at least try. And there are options for that. So talk with them about their preferences. Take advantages about programs allowing a child to stay in high school. If your kiddo should maybe stay in school past the age of 18, in Texas, they can. I'm not an education attorney, so questions about that should be pointed back at Sasanu and Julia. But also consider the fact that they might need to change from pediatric specialists and pediatricians into adult special pediatricians. You need to build that medical record to pursue the disability benefits. So be prepared for that easy transition into new specialists. And take it seriously. These deadlines are quick. You're gonna have to be ready for the potentiality that Social Security is gonna come and say, kiddo is no longer disabled. And if you have all that stuff prepared, you've already had these discussions, you're prepped with medical records, it's gonna be a lot easier. The final thing that I wanna say that I thought of during the education presentation is that the specificity of those IEP documents and those ARD documents make total differences in what we are able to argue. So if you know that they are adding different things casually through the day for your kiddo through school to help them, make sure it gets listed in that document, because then I have written proof when I go with you to Social Security to say, these are the kinds of things this person needs to function. Do you think a work environment would be able to sustain that?
Just so you know, we're going to have just a few more minutes. Julie and Amber have been very nice and said we can answer questions. So we're going to finish the presentation. It's just a couple more slides, and then we will answer questions. Just want to make sure everybody knows that. So next slide.
This is the big area. So,
and it's complicated. Let's see, where is it? Oh, there.
okay. So disabled young adults and guardianship. So it's been touched on a little bit back and forth through some different presentations. And this is a very scary moment for caregivers of children with disabilities, is that 18th birthday. They don't know what to do, right? There's a lot of options and a lot of misinformation. So when that kiddo turns 18, they are legally an adult. And particularly for kids with intellectual or psychiatric disabilities, there's a lot of concerns. The one thing, like Renee's one slide earlier, if you take nothing else away from my portion of this presentation, what I need you to understand is that people on the phone lines at Social Security and Texas Health and Human Services Commission, while well-intentioned and very steeped in their areas of what they do, are not guardianship certified attorneys, I would guess, very frequently. And so they do not have the ability to talk about whether or not a kiddo needs guardianship. So don't just listen when someone says your kid needs guardianship when they turn 18, otherwise we won't deal with you. There are alternatives and you need to discuss those alternatives.
Just real quick, I want something that was on the previous slide that we didn't touch on. If you get a redetermination, if you're somebody who is getting disability insurance or SSI for yourself or for a child, and you get a notice saying that you're no longer medically eligible for benefits, make sure you file an appeal in 10 days. Because if you file an appeal within 10 days, you can request continuing benefits while you wait for a decision on the appeal. And you have to understand right now, a Social Security hearing is going to probably take 2 years before you get it. So at least a year, but up to 2 years, because the pandemic has put Social Security behind on their schedule even more. So make sure if you get some type of letter that says your Social Security benefits are going to end, appeal and request continuing benefits pending the outcome of the appeal. All right, so Anna?
Okay, yep, and so what are guardianship alternatives, right? If maybe kiddo is not doesn't need a guardianship, what other things can be there to help them? So these are generally, this is very quick. I mean, we do hour-long presentations on this. So if you're left with questions, please feel free to reach out. But basically, these are documents or programs that support an individual with disabilities and empower them as they learn to make their own decisions. These include a supported decision-making agreement. Powers of attorney have been touched on many times in the different things that they do. Also considered guardianship alternatives are programs like the representative payee program, so that maybe kiddo just has a tough time with money management. Don't get a guardianship because your 18-year-old doesn't understand money. I wish that someone had been able to handle my money when I turned 18, right? But these things can be handled very easily without the cost and the enormity of guardianship. And I think we have one more slide.
I think so. And guardianship, actually, I'm sorry for interrupting, Anna, but the next presentation is going to be Julie Balovich and Amber Bertsch, and they're going to be talking about guardianships versus custody. So on this, the most important thing Anna's already said about guardianship is don't get one or start the process just because somebody at Social Security or Health and Human Services Commission said you need one, or your friend has one and says you need one also. It's a very fact-specific, family-specific decision. Also, remember, guardianship means there's a court order that says that adult has no legal rights.
Yeah.
You make all the decisions for that adult.
The process is suing your own child or grandchild for their rights, right? And that decision should not be entered into lightly. If it is necessary, however, and there are situations where it is, I mentioned I was guardianship certified. Julie Balovich, who's going to be speaking momentarily, is. I don't know if anybody else on this call is, but not every attorney is. And in order to get a guardianship, you have to be dealing with a guardianship certified attorney. So make sure that the attorney that you have gone to for the guardianship is guardianship certified through the State Bar of Texas, and you can actually find that out online. Another important thing is if guardianship is going to be necessary, even with the assistance of free legal counsel, there are times that it can be expensive and there are costs that you're going to have to pay. So you may need to do some saving up while keeping in mind the things we've told you about not having too many resources due to public benefits. Very complicated stuff. Feel free to call us. And our number and our information is listed here. So thank you so much. I know that was very fast on guardianship and alternatives. So if anybody has any questions, feel free to drop them.
Okay, so we do have a question. And this is a 21-year-old who, whenever work gets difficult, will just leave work. Or let me say, who leaves work when things get tough. He only works part-time. If he does that now on part-time, how can he hold a full-time job? Thankfully, his company is very understanding. He's on SSI. Now, what you have to understand is once, as an adult, which he is at 21, the question is whether or not he can work. Now, work is not just holding down a part-time job. There's actually a dollar amount. It's called substantial gainful activity. We don't have time to go into that detail, but when somebody is working, the Social Security Administration looks at how much they work and how much they earn every month. And there's a couple of different things you have to think about. There is one, you have to report this person is working to Social Security. You have to do that. And you have to tell them what money that person is earning. So this grandchild, their income has to be reported to the Social Security Administration, and the money being earned is going to affect the amount of benefits they're eligible for each month. And it could fluctuate. If income fluctuates, benefits fluctuate with SSI. So that's one. Two, there's something called a ticket to work program. And so if somebody is attempting to work, they should look into the ticket to work program. That's with the Social Security Administration. They have counselors to help people figure out if they're able to work. And it's not only the ability to obtain employment, it's the ability to maintain employment. So I have represented many people over the years who are able to get jobs, they just can't keep the job because of either a psychiatric or intellectual functioning issue or a physical issue that prevents them from being able to keep a job. So very fact-specific situation. Make sure you report it, that they're working, make sure you're reporting the earnings every month, and try to get into the ticket to work program, and you can still appeal the denial or the termination of Social Security benefits if you believe that person continues to be disabled according to Social Security rules.
And if the reason that they can keep a job is because their employer is doing a lot for them and being very understanding, like your message implied, that in itself might mean that their disability is continuing and they wouldn't be able to hold a different job.
It's called a sheltered work environment. So if the requirements of the job and the flexibility that the employer gives is more than any other employer would give, then that can also be something that can be discussed to explain that he still remains disabled. It's just he's able to work in this very, very limited situation where he's getting special treatment. It's kind of like special accommodations at school in special education. If the work environment is also that way, there might be a shelter work environment argument. All right, so that is all the time we have, plus 5 minutes. Thank you to Amber and Julie for giving up a little bit of their time. And what we're going to do now is we're just going to go straight into, let me get rid of my presentation. We're going to go straight into the next session. Just a moment, let me pull this up. So this is a session on child custody versus guardianship, and I believe it's going to be specifically geared towards minors, so children under age 18. But I will let Julie and Amber tell you a lot more about that.
Thank you, Renee. Can everybody hear me okay?
You can speak up just a little bit more.
Okay, can you hear me now?
Yes.
Great. All right. Thank you very much for that. I'm Julie Balovich. I manage the guardianship and kin care team at Texas Rio Grande Legal Aid. My colleague Amber Van Skyver oversees the family law practice. And what we're going to talk about are basically court orders and written permission, things, the laws that let you take care of your grandchildren when they are children. People who are taking care of their grandchildren are doing it for a lot of reasons. It may be that the parents have passed away. It may be that the parents themselves are incapacitated. They could be in jail. They could be out of the picture for a variety of reasons, both temporary and permanent. And we see a lot of folks come to us and they're saying, I need custody, I need guardianship, and it can be very stressful. So the first half of this presentation, I'm going to talk about the things that you can do without court orders, because for reasons that we're going to get into, that may be the most practical thing. Then the end of the presentation, Amber is going to talk specifically about custody orders. So I'll go ahead and get started. So what are the legal options for non-parent caregivers? We're going to talk first of all about when you have nothing in writing, what you're able to do. I'm then going to talk about powers of attorney and a document called an authorization agreement for non-parents, which is another type of power of attorney. I'm going to talk very briefly about guardianship of minors. And then, like I said, Amber is going to end the presentation talking about suits affecting parent-child relationships, also known as custody orders. So what if you have no court order and you have nothing in writing from the parent of the child? You're a grandparent, you're taking care of your grandchild, and you're concerned about getting them in school, taking care of kind of the essential things. So what's really important to understand is there's no child in the state of Texas who should not be in school, regardless of whether they have a parent or somebody with a custody order there to admit them. The laws in Texas state that children must be admitted, even if they are living apart from a parent, even if they are homeless. And so when folks come to us and they say, I'm taking care of my grandchild, the school is not letting them in, that is an issue with the school that should be addressed. The first thing I would recommend is, first of all, make sure you've tried to admit the child to school, because a lot of times, like Renee was saying with folks at Social Security, you may be told something just by a person at the front desk who doesn't really know what the law is and is used to asking for a custody order. Try to admit them. If you're getting an obstacle, there is a homeless liaison that every school district has, and their job is to make sure that children who are displaced for whatever reasons from their parents are able to get in school. So ask to speak to the homeless liaison if you're getting obstacles, And if you continue to get obstacles, then that is something definitely to address with an attorney, because no school district should not be admitting a child to school. There may be time needed in order to get a custody order, get some sort of legal authority, but they shouldn't be delayed because of that. The second thing is public benefits. You just heard a presentation about Medicaid, about SNAP, about Social Security and TANF. And Renee talked about the very broad definition of what a caretaker is, which includes all sorts of family members, and those include grandparents. If a child is living with a grandparent, and that grandparent is taking care of them and they're part of that household, then you do not need a custody order or written permission in order to add that child to public benefits, to make sure that they get SNAP and Medicaid. And again, this may be an issue of you're talking to the wrong person, but don't not apply for benefits for these children if you're taking care of them, if they need them. And you can apply for child only Medicaid. If they're denied, as Renee mentioned, there is an opportunity to appeal that. And that's what I would recommend that you do. Don't not apply for it. Finally, the consent to medical treatment. There's a provision in Chapter 32 of the Family Code, and I don't expect you to remember that, that says that if a grandparent, an adult sibling, or an aunt or uncle is taking care of a child and the parents can't be located and the parents don't object, then those persons can consent to medical treatment. So what the law says is that a doctor or a nurse or a healthcare provider that's providing treatment is immunized from liability if the parents can't be found and if they don't object. It doesn't require them to treat them. It just says that they can. And a lot of times this will work. A lot of times folks will come and they'll say, I need a custody order because I need to take my grandchild to the doctor. Mom or dad is in jail, or we don't know who dad is, and mom has disappeared. And simply alerting the doctor's office to parents can't be found, they don't object, I've been caring for this child for a while, will allow them to consent to the medical treatment. And there's actually a form that you can fill out. One of the things we're going to have a slide for at the end, and it was also in the chat that Renee posed, is that Texas Kin Care Primer includes references to all of these things. So the law that I just mentioned, Chapter 32 of the Family Code, is in there, and it shows the form that you can send to a doctor if you're taking care of a child. So generally speaking, if you're taking care of your grandchild and the only issues you have are school, public benefits, and medical treatment, these are things you should be able to do even without written consent, and even without a custody order. What about, there's also a few other things that you can typically do without power of attorney or consent. And these can be a little more case by case specific. But generally speaking, a child who is in your household for whom you are providing more than half of their support for the year, and they're not claimed by somebody else as a dependent, grandparents may be able to claim them as a dependent on their taxes, and claim the earned income tax credit and the child tax credit if those apply. You need to obviously look at the rules for claiming that credit and make sure that they meet the criteria, but it is not fatal if you don't have written permission or you don't have a custody order to get that tax credit. We do sometimes see cases where folks are audited by IRS because they want to see that written proof. And obviously a power of attorney or custody order can be helpful, but other documentation that you're providing for that child can be helpful as well. The other thing is under the Affordable Care Act, dependents can be covered up to the age of 26. And you have to look at your insurance policy. If you have insurance through your work, look at the definition of dependent, because a lot of times it may dovetail with the definition of who you can claim as a dependent on your taxes. So it's not going to work in every case. I think TRICARE is going to require an actual custody order, but look at your definition. It's not necessarily required to have a custody order. And then finally, if you're working and you need to take leave to take care of a grandchild who's in your care, under the FMLA, that child, again, could meet the definition of somebody for whom you can claim FMLA leave. It's a child for whom you have day-to-day responsibilities. And there's other requirements for whether FMLA applies to your specific job, but just generally speaking, these things can be in the universe of things that you can do without written consent or a court order. Okay, so those are the things that you can do if you're in a circumstance and you're a grandparent and you're taking care of your grandchild and you don't have anything in writing. But that's not ideal, right? Because things are going to come up. So what about powers of attorney and what about authorization agreements? So powers of attorney are basically where a person gives authority to somebody else to do things that they have authority to do. That's my very general layperson definition of a power of attorney. And so for purposes of taking care of a minor child, if I'm a parent and I can give some of the powers that I have as a parent to somebody else in a power of attorney. Now there's some specific restrictions on this, right? So I cannot give powers that I don't have. So if I'm a parent who has a divorce and my spouse has primary custody and I just have visitation rights, well, I'm not going to be able to give primary custody with a power of attorney. I'm only going to be able to give whatever authority I have. So that's one restriction on that. Another restriction on it is generally these need to be notarized. They can be revocable and they can be written in plain language. So powers of attorney can be very flexible. It's always a good idea to have an attorney prepare one, of course, but I have seen powers of attorney that are handwritten by somebody. They really just need to be notarized. And as long as they don't supersede the rights of another parent, they are going to work for most parent purposes. So a power of attorney that says, I, Julie, give authority to my mom, who is my child's grandmother, to take this child to school, to make medical decisions, to apply for public benefits. And if I get that notarized, that should be good for most purposes. What you'll see, though, is a lot of folks want that to be more formalized. And that's why, A, it's nice to have it prepared by a lawyer. But two, a few years ago, Texas passed a law called the Authorization Agreement for Non-Parents. And what this is it's a statutory power of attorney for taking care of minor children. And by statutory, what I mean is this form comes from a statute. It's Chapter 34 of the Family Code, and it's actually a form. You can Google it, for example. You can find it on a lot of websites. You can find it in the Texas Kin Care Primer. And that makes it really easy to use because it is a pre-printed form. It's something that you can fill out. And what I have here is I've actually just cut and pasted pictures of this form so I can walk you through how simple it is. Let me just change my screen so I can make sure I can see it. So this is the first page of the form, and what it states is that this authorization agreement is made in conformance with Chapter 34 of the Texas Family Code. First blank, child's full name, date of birth. Second, the parent who is completing this form, their name, their address, their phone number, and other contact information, which may be their email address. Then you list the child's other parents. Then it says the parent voluntarily authorizes the following adult caregiver or parental child safety placement caregiver, and that means if you have the child under a CPS safety plan, to make decisions regarding the child. And so you list the person who is the adult caregiver, their name, what their relationship is, their address, and their phone number. The second page of the form lists what authority that caregiver has under the law. And it's pretty broad, right? It's authorizing all medical treatment, maintaining health insurance coverage, enrolling them in daycare. So that's something, it could be daycare, it could be something like Head Start, authorizing them to engage in extracurricular activities, helping them get a learner's permit, driver's license, or state issued ID card, authorizing employment of the child, public benefits, and this is super important, getting copies of state issued personal ID documents. So if you need that birth certificate, this form can help you get that. What this doesn't do is allow the voluntary caregiver the right to authorize performance of an abortion or the administration of emergency contraception to the child. So that is a limitation. And one of the things that you have to check off if you're going to use this form is that this child is not the subject of an authorization agreement that already exists, and that there's nobody who is going to claim possession of the child inconsistent with the authorization agreement. What does that mean? If there is an actual custody order out there for this child, you can use this agreement, but you're going to have to get court authorization to do that. So using an authorization agreement, if there's already a custody order, a divorce decree, or a child support order is okay. That court's just going to have to sign off on this. So again, this is something very specific that you have to check off. There is no court involvement, or this child has been the subject of a court order, and they want you to staple a copy of the court's order to this agreement. And it says this court with continuing jurisdiction has given written approval for this document. What does that mean? It basically means you need to go to the court, to a judge of the court that issued that order, and get them to write approved on this. And there are ways to do that by filing kind of simple motions. The authorization agreement lasts automatically from 6 months and then renews automatically, or you can put a time in it that it expires before the 6 months. If the parent doesn't want it to last for 6 months and they don't want to renew it automatically, they need to write into the agreement, this is when I want this to expire. So for example, let's say a parent is going to be out of the country for a couple of months. They want to give authority to somebody. They want to make sure it only lasts for that couple of months. They don't have any issues. They can put that date in there. One thing that's real important to emphasize is this is a voluntary agreement. It actually can be terminated at any time. So the idea of making it renewable for every 6 months doesn't mean the parent gives up the ability to revoke it before then. And then this is where it's signed. The parent and the voluntary adult caregiver each sign it before a notary. So what if you only have one parent to sign this? Well, that's okay as long as the other parent gets notice by certified mail, return receipt requested at whatever address you have for that parent. There are some provisions where you don't have to give notice to that parent if they have been convicted of a domestic violence crime, or if there's a protective order. You want to look real carefully at the instructions if you're going to bypass that. Generally speaking, I would really only use this agreement if you have both parents to sign off on it, or if you can make sure you have the ability to safely give the other parent notice, so there's no questions about the validity of the agreement. So as Renee mentioned, I'm going to talk very briefly, one slide briefly about guardianships of a minor child. You may hear the term custody and guardianship used interchangeably. They mean different things, okay? When you're talking about an adult, a person over age 18, then guardianships really only come into a play when that person has some type of incapacity, an intellectual disability, neurocognitive decline, something that impacts the adult's ability to take care of themselves. For minor children, a guardianship is only appropriate if both parents are deceased, or if you're talking about a child who has property, a child who has inherited money. If you are looking to take care of a child, you are usually going to be looking at a custody order, not a guardianship order, if you're really only trying to take care of the person. Guardianships are filed in probate courts. The probate court jurisdiction is really generally about people who are deceased or incapacitated. So most probate judges are not going to want to see a guardianship of the person if there is a parent out there and you're saying that that parent can't take care of the child. It doesn't mean you can never do it. It just means they're really not preferred. And if in any way they get contested, that case is going to get transferred to a custody court anyway. But if the child inherits property, let's say they have a big life insurance estate, or as Carol mentioned in the beginning, you know, they are left property in an inheritance and they don't have the ability to manage it, then that may be where a guardianship needs to be done. And in that case, just the things to know, they have to be renewed every year. The guardian has to post a bond, which if it's for guardianship of the person is about $130 a year unless there's an estate. And as Anna mentioned, these can only be filed by attorneys certified in guardianship law. And as Anna also mentioned, they are not required to manage Social Security benefits or public benefits. You can use other alternatives in order to do that. So I'm now going to turn this over to Amber to talk about custody orders.
Thank you, Julie. So before I get started about going into detail about what we call suit affecting parent-child relationships, but is also known as custody orders, you might also hear them referred to as sometimes as OAG orders or child support orders. They have lots of different nicknames here in Texas. Is just to remind you all, right, that you may hear from a lot of different people that you need to get custody orders, and that may not be required in your particular situation. So just keep that in mind as we're going through this. The custody process can be complex and expensive. So we're going to be going over it very briefly today, but if you have additional questions about the process, I do recommend that you consult with an attorney because, as Renee pointed out, with everything in the law, there's exceptions to exceptions, right? And this process can be complex. Okay, sorry about that. So a custody order is generally a court order that includes orders for custody. That includes both who the child's going to be living with and also who's going to be taking care of the child. And visitation, meaning who has a right to visit with the child and when, and also child support. Who's going to pay to help support the child. And as part of the process of getting custody, you have to show that you have the right to file the lawsuit. In Texas, we call that standing. And so I want you to think of standing as sort of a locked door. To get in to file a custody suit, you have to show that you meet certain grounds before you can go through that door, right? In Texas, not anybody can file a suit for custody. You have to show that you meet one of these grounds. And so those grounds include things like the child's been living with you, you've been taking care of the child for at least 6 months, or if the child and the child's parent have been living with you for at least 6 months and the parent is now deceased. Now there's a caveat for both of these situations. You have to file the lawsuit within 3 months, 90 days of when the child stops residing with you. So if the child was living with you for 6 months, but that was a year ago, you won't be able to file, you won't have standing under that situation. You'll have to file within 9 months of when the child was last living with you. You can also have standing as a grandparent if both parents are deceased or the living parent or the parent that has primary custody consents to you filing the lawsuit. Or if you can show that the child's current living situation is putting the child in significant danger, either physically or would cause significant harm to their emotional development. So once you meet those grounds for standing, then you also have to give notice to the parents. And typically that's done by giving through personal service. If you are unable to locate one or both of the parents, and we'll talk about kind of what that means in just a minute, but the court will have to appoint an attorney ad litem to represent the parents in the case. And they will check to make sure that there have been significant efforts to locate those parents. If there has been an order in the past for the children, you'll have to meet a couple of additional hurdles. First of all, any case, if you're trying to change an order that's already been in place, typically filed in the court that made the original order. So that may be a little bit more complicated, right? If the case was in a different county, right, than where you currently reside. Then you also have to show that there's been a significant change since the last order was entered. So keep that in mind if there were orders already in place. Also, it's really important to note that in Texas, we have a preference for parents having custody of their children. What that means as a grandparent trying to get custody of your grandchild, is there's a significant burden to overcome in trying to get custody if the parents are not in agreement. You have to show that the parent is unfit, meaning that the parent having custody would either significantly harm the child's physical or emotional development. And it's a very high standard, which makes these cases very complicated if the parents are not in agreement for custody. If it's a contested case, right, meaning not agreed, it can get very complicated and get very expensive. So as I mentioned, if you are trying to locate the parents, you have to show what's called due diligence. So typically you have to serve the parents personally. But if you can't locate the parents, you have to try multiple different ways to locate the parents before the court will approve any alternative options for service. So what that includes, and it's not just a matter of saying, well, I haven't talked to them a while, I don't know where they're at, right? You have to show that you've made multiple attempts to try to locate them. So you'll have to do things like try to locate them at their last known address, doing an internet or social media search, calling friends, family, employers. If you think the person might be incarcerated, you'll have to check online and see if you can locate the facility they're incarcerated at. If you're trying to get custody, you'll still have to serve that parent even if they're incarcerated. So you'll have to try to find out where they're incarcerated at. And if you don't take these steps and you don't notify a parent, the court may not allow you to go forward. And even if the court does proceed and you didn't take the necessary steps to try to locate the parent, the order could be void, which is it could be a very big problem. So not only do you have those service issues, but the case can also get very expensive. In Bexar County, to file a custody suit, it's about $328. And then you'll have to serve the parents, right? Which is usually runs about $93 for most types of service in Bexar County. There could also be ad litem fees, right? If you can't locate the parents. The court could also appoint a court-appointed professional. They often do that in contested suits involving non-parents. They might appoint an amicus attorney or some other individual to look into the well-being of the child, investigate the parties. The case can get very expensive very fast. You can file a statement of inability to pay costs, which is just a form that includes your income, your expenses, and the court can waive court fees, but the court will have to determine which fees will be waived. So here's the overall process in obtaining a custody order, right? So you have to file the suit, and it may be very important, depending on whether there was a prior order or not, where you file the suit at. And you, in your petition, your request for custody, you'll have to lay out those grounds for why you're able to file the case, those standing grounds, right? Then once you file the case, you'll have to give service to the parents. You'll have to notify them. And if you can't find them, right, you'll have to request the court appoint an attorney ad litem to represent the absent parent, and that will delay the case. And then if you need temporary orders, the court can make orders that will be in place temporarily while the case is pending. For example, so that the child can stay with you while the case is pending, or if you need temporary child support, things of that nature. And then once the case is ready to be finalized, the court will have a final hearing and make a final order. The case can last for quite some time, depending on whether the case is agreed or not. If there's court professionals appointed, the case can last much longer. Right now with the pandemic, almost all court cases are being delayed somewhat. So it's just important to keep in mind that the process can take some time. There are options for assistance if you are looking into this, and this is something that you need to have in place for your grandchildren. So one option is if the parents are in agreement, you may be able to go ahead and file this in court on your own. There are forms online on Texas Law Help that we've included the link for to obtain custody orders if you're not the child's parent. And then if the child has been living with you for at least 6 months, the Office of the Attorney General, their Child Support Division, may be willing to assist you in getting orders in place for the children. So a couple things to keep in mind if you are requesting assistance from the Office of the Attorney General. One, they represent the state, so they won't be acting as your attorney or an attorney for either of the parents. Their primary goal in any case is to obtain child support orders. So they're going to be particularly interested in cases where the children are receiving benefits. And if the case becomes contested, meaning the parents are not in agreement, they will not choose a side. So they don't represent either party. Okay. And they will, as part of the process, they will be requesting that the parents pay child support. If there's no agreement, meaning the parents are not in agreement for you as a grandparent to obtain custody, and the child support office will not assist, then you'll need to hire a private attorney. And as I said, especially these cases are contested, they get very expensive quickly. So keep that in mind. So the takeaways here are to keep in mind that the process can be very time consuming and expensive. And in most cases, a custody order is not required. And I do want to just point out a couple of other things to keep in mind with custody orders. So as a non-parent, if you do obtain custody of your grandchildren, you will need to file an annual report with the court, letting them know how the child is doing every year. So it's an additional step that you'll have to take as a grandparent with custody. Also, the custody order is semi-permanent, right? So a parent can go back to court and ask to modify it, but once you have rights as a grandparent, either as having custody or having visitation rights, you're in the case until the child's 18. So just keep that in mind. It's not a good option for grandparents seeking, temporary rights to care for their children. But what I do want to talk to you about next is an option specifically for grandparents needing something in place temporarily when you can't get one of those forms that Julie mentioned, right? The power of attorney or the temporary authorization agreement. And this is a relatively new law that we have here in Texas. It's called a petition for temporary authorization. And this is specifically available for a number of individuals, including grandparents who are taking care of their grandchildren. And this is available if the grandchildren have been living with you for at least 30 days. It's a relatively simple and quick court process, unlike the custody order process. And it works if you're not able to get one of those other agreements, right? Either the power of attorney or the authorization agreement. So in order to get this, the child has to have lived with you for at least 30 days. And it's a petition that you file with the court. And it can provide consent for medical, dental, psychological, surgical treatment, and immunizations. It can also provide consent for releases of information, right, for medical treatment or immunizations, obtaining public benefits, enrolling the child in daycare, preschool, primary or secondary school, both public and private, and to participate in recreational activities, extracurricular activities, including athletic activities. And there's also this catch-all where the court can authorize consent for any other needs essential for the child's well-being, right? Now, the court can only grant this petition for temporary authorization if a parent does not object. And so you have to give notice to the parent at the last known address, either by personal service or certified mail. And if the parent files an objection at any time, the court has to withdraw the temporary authorization. The court can only grant the temporary authorization because it's temporary for 1 year. So it expires after 1 year. However, you can go back to court and ask for it to be renewed for up to 1 year. And so we did just want to also make you aware, and these were mentioned several times earlier, right, of some other local resources that are available. The Texas Law Help website, which we've mentioned several times, it is very different than most other resources you will find on the internet. It's specifically been developed by Texas attorneys to provide free legal resources online, both self-help forms and also lots of legal information, lots of answers to questions that you might have about different legal issues. They have a specific page for kin care assistance that has most of the forms that we've been talking about today. So if you have additional questions or want to go online and check out those forms, I do really recommend that resource. Of course, we at TRLA are also available Monday through Friday from 9 to 5 for applications. I do just want to note, while we do provide assistance for things like power of attorneys, educational issues, public benefits, medical issues, we unfortunately do not have enough resources to assist in most custody cases. So please keep that in mind. Unfortunately, we just don't have the resources to assist in all of those cases, especially given the complexity of those cases. And with that, we'll go ahead and open it up to any questions.
So Amber, there's some questions that are kind of specific and I'm going to generalize them. Can you talk about experientially what you see about when CPS becomes involved in a case where, for whatever circumstances, the parents aren't in the picture, they've left the child, maybe they're in jail and a non-parent is taking care of them. And then there's a concern that that parent is going to come back. What is your experience of what CPS does in those cases?
So CPS will usually, if they're getting involved, they'll ask the parties to sign a safety plan, and they may temporarily place the child with non-parents, right? And that could be a grandparent. The thing is to keep in mind is that safety plan is usually only valid for a certain period of time. So it's usually 30 days. However, they can extend it for longer. And once that safety plan expires, the parent does have a right to come back and pick up the child. Now, if CPS has ongoing concerns, they may, like I said, renew that safety plan. But after that safety plan expires, the parent has the right to come pick up the children. So if there's ongoing concerns, that might be a situation that would call for filing a suit, but you'd have to meet those standing grounds, right? And so that's where it gets a little bit more complicated.
And when is it that CPS would actually take that step of filing a suit?
So CPS would have to have very serious concerns to file a lawsuit. And when they file a lawsuit, typically it's called for termination of parental rights, although even though they're filing to terminate the parental rights, their goal, their set out goal in any case, right, is for a parental reunification. So they will file the lawsuit, and there has to be a hearing very quickly in those cases where they remove the children from the parents. And then at that hearing, they'll determine if the removal was necessary. And they'll try to place the children with a family member first. they're going to ask the parents typically for someone to place the children with. And as part of that process, they may require a home study. They're typically not going to place the children with any person who has criminal record or has past CPS involvement. So that's something to keep in mind as well.
And in terms of the criminal record and back CPS involvement, do you know if that's like a per se every single time, or is it situational? Do you know what their guidelines are?
I don't know off the top of my head.
Okay, but they're generally either for a safety plan or for a kin care placement that is pursuant to even a suit that they file. They're going to do a background check on those family members, right?
Yes, they will do a background check before they place the child with any family member.
So you also mentioned in when a non-parent gets an actual custody order, there's a requirement that they have an annual report with the court. Is there a form or a template out there for that annual report?
I believe there is. I'm not sure if it's on Texas Law Help, but I believe there is a form.
And if folks have issues with CPS, if they're non-parents, what are the resources out there for them?
I'm sorry?
What are the resources out there for them if folks have issues with CPS, if they're on the other side of CPS?
So there is a hotline, and I can share that information in the chat that you can call for issues specifically related to CPS. There is also a wonderful guide that is on the Texas Law Help website, handbook specifically for families involved in the CPS process that really breaks down the process and talks about the various different steps, what to expect, how to work with a CPS caseworker, what they might ask for. It really breaks down the process because these cases are quite complex. There's a lot of hearings, especially if CPS has filed a lawsuit. And so it can get very overwhelming very fast. And so we can share that I can share that information in the chat.
And is that the TLSC or the Texas Law Help?
Yes.
Okay. So there's an agency called Texas Legal Services Center. I'll let you type that in while I'm explaining it. So Texas Legal Services Center is a statewide agency. Texas Rio Grande Legal Aid is a legal aid that just serves Southwest Texas, including Bexar County. But Texas Legal Services Center is broadly across the state of Texas. They have a hotline for people over the age of 60 for all sorts of issues, including kin care. But they have also set up a lot of specific hotlines for particular legal issues. And the one that Amber is referencing is a hotline that they've set up for folks who are having questions about CPS. There are points in a CPS case where parents who are subject of the CPS case become entitled to court-appointed representation. Non-parents, not so much, unless they are the subject of the CPS proceeding. But this hotline, I think, can answer questions for both. Is that right, Amber? Okay. There was another question, Amber. Can you talk a little bit about the concept of abandonment by a parent? If a parent disappears, how does that become relevant to either the standing that you talked about or rebutting the parental presumption?
So if a parent has abandoned the child, which we typically, you can use that both to rebut that parental presumption, right? That the parent is fit if the parent has abandoned the child. And you can also use that for that standing step, right? So if you've been caring for the child, right, and the parent has left the child with you, that helps rebut the parental presumption in Texas if the parent has left the child with you for 6 months or more.
And then there was a question about the legal hotline for Texans. So this is for persons who are over 60. That number is 800-622-2520. And it's option 3. And that is also on the texaslawhelp.org website. Let me see if I can get that typed in real quick. Okay, let me see if there are any other questions. I think that is it. Oh, there was a question about the interplay about the authorization agreement and a custody order. So the idea about an authorization agreement is you are a non-parent, you are caring for a child, you are encountering obstacles with school, with the doctor, just things that you need to take. Maybe you need to get a birth certificate. The parents can sign the authorization agreement to an adult caregiver to give them authority. If the parents have a custody order, a divorce decree, a child support order, if any court has made orders for that child, that court needs to approve it before the parents sign the authorization agreement. If a non-parent already has a custody order, they don't need to then get the authorization agreement. The non-parent custody order is going to control. So there's another question, Amber, about child support. At what point does a parent get ordered to pay child support if a non-parent is caring for a child?
If a non-parent
And what if it's non-voluntary? What if they're not in agreement? They don't want to do it.
If a non-parent's caring for a child, both parents legally have an obligation to support the child. So generally the court's going to seek child support from both parents, whether they're in agreement or not.
Amber, how would a grandparent try to get child support if the parents are unwilling to cooperate in the process?
So the number we provided for the Attorney General's office, they will typically assist if you know how to locate the parents. Now, if a parent is in another country, for example, or you don't have any contact information, they're less likely to get involved. They typically prefer to get involved in cases where the children are receiving benefits. Those are their top priority cases, but they will seek child support from the parents as part of the process.
Amber, what about the custody order? If somebody gets a custody order in Texas, will that work in another state?
Yes.
Okay. That's called the full faith and credit. Every state has to honor the orders from another state. But in terms of what I talked about the first half of this presentation with the things that you can do under Texas law without a court order or without written permission, that's Texas law. If you are in another state and you don't have a court order, you're going to need to consult an attorney from that state about what you are able to do if you don't have legal custody.
And Julie, I just want to clarify something because one of the questions was about parents giving up rights. So for a custody case, a parent is not giving up all of their rights. The court may limit their rights as part of that custody order, but it does not end that parent's parental rights. A custody order typically will specify, right, if the court's awarding a grandparent custody, primary custody, the grandparent will have primary rights, but the parent will still retain some rights. But those are typically, those can be limited by the court's discretion. And the main factor in any of these court decisions, right, with custody for a child is always going to be what is best for the child. But you have to keep in mind that the courts do give a strong preference for parents in these cases.
So I think that ends, that is all of the questions that have been posted. So again, in the chat, there's texaslawhelp.org, which just has a ton of information. There is a chat live with an attorney option where if you have questions about filling out these forms, you can answer. You've gotten our hotline number, and then the Texas Legal Services Center numbers for resources. And I think I'll turn this back over to, is Mercedes still with us? Renee, who's
I believe Mercedes is still with us.
I am still here. I was just muted. Well, thank you very much. I really appreciate everybody's wonderful information. This has been extraordinary, even beneficial to me to be able to help grandparents out there. I appreciate that we're going to have this recording and be able to do more training with it. Thank you so much to each and every one of you that has participated and shared such wonderful resources and information.
Well, thank you for the invitation to do this, Mercedes. We greatly appreciate it and are available to do future trainings if you would like. The other thing, the recordings will initially be available on the TRLA website, which is www.trla.org. And so if anybody wants to view it again, it should be there, if not immediately, soon.
Thank
So,
you.
Thank you, everybody,
Thank you.
for attending. Do we have any last things that we want to say? All right.
Yep. Thank you.
Thank you, everybody. Enjoy your and the rest of your weekend. Thank you.
Thank you.